Okay, we'll open up the public hearing on House Bill 1404 and hear from the prime sponsor, Representative Inventine.
To speak. I submitted House Bill 1404 at a request of a constituent in Manchester. I am going to request that this committee ITL the bill as written, but I would like to speak as to why it was presented, Mr. Chairman. The individual came to me very upset about some issues that occurred, and I'd like to explain that. An individual had their car towed from their apartment complex. The apartment complex blamed the tow company, said, well, we give them the right to do that if cars are illegally parked. That was not the case. And it was I want you to pay for it, Mr. Landlord. No, I'm not going to pay for it. Well, why did you let them tow my car? Whose fault is it? And then I got into that. But that was only part of the problem. The other problem is the individual had to pay to get their car from the tow company. But in their vehicle were some of their personal items, including the only thing they could do on a Saturday morning was a debit card. Sorry, that was Mom. Was a debit card. Well, guess what the debit card was? In the car. So they went to get the car, and they said, well, it's $40 to us to let you go in and get your personal items from your vehicle. Well, I don't have $40. I need my debit card to be able to get the money to get the car out. Well, go borrow it from someone. Really? I have to go borrow $40 from a friend to get into my car, to pay you to get into my car so I can get my debit card, to go to the bank, to get the money, to pay my car out of hock that was towed from my apartment complex when my car was parked legally with a sticker on my car. So obviously she was quite upset. She presented a bill, which I have in front of you, which I had requested some of the stuff be taken out by legislative services, but we all know what happened last year when everything was put together in 1 week. I would never put a bill forth that would have a price tag on something, because then what happens is, we all know in the legislature, if you put a price tag on something, that has to be always amended year after year after year with inflation or what have you. Regardless, then Gary Abbott from the AGC explained to me that a bill had passed last year making some significant amendments to rules and laws regarding towing, mostly for commercial. So I wanted you to hear that story. There are bad apples in every industry, in the insurance industry. Where I sit, every once in a while we have a situation, and that's why the insurance commissioner can take our licenses away if we don't follow the rules. This was a really bad situation. It shouldn't have happened. It shouldn't happen again. I don't think it rises to the level that we need to go after everybody that does follow the rules and is compassionate about what they do and are responsible for how they operate their towing business. But it's a bad story that I wanted you to at least hear. That being said, I'm happy to take your questions, but I respectfully request that you take my bill and put it in the trash can and ITL it at your earliest convenience. Today would be preferable. Mr. Chairman.
Okay, do we have any questions from the committee members? Seeing none, thank you very much.
Come on over to labor whenever you want, folks. All right, thank you.
Okay, so given that the sponsor would like the bill to die, and every card I have in front of me is opposed to the bill, I would just say that the model of brevity would be appreciated. Brittany Shute? Is that a T? Shute? From the Department of Motor Vehicles. Great. We always honor every card. You can say I have nothing to say.
Good morning. Well, I'm Brittany Shute. I am here on behalf of the Division of Motor Vehicles, Bureau of Title and Anti-Theft. After that, I wasn't quite sure if what I had to say would add to that at all. We are opposed as written. It's introducing 265-108-A. This statute already exists as parade vehicles, and that's the biggest fault that we found with this. We do feel that people should be able to obtain their vehicles without exorbitant fees, but aside from that, mostly 265-108-A already exists in statute. And with that, I'll be happy to take any questions.
Do we have any questions? Oh, we do have a question. Representative Abel.
I just wanted to know if the existing statute would how it deals with this, this kind of instance.
Thank you for your question. The current statute, 265-108A, is for parade vehicles, no relation.
Great, thank you very much.
Thank you.
Chair will call on Ralph Creston, New Hampshire Towing Association.
Good morning.
Good morning.
My name's Ralph Presser. I'm the president of New Hampshire Towing Association.
Oh, yeah, gotta push the red, just push the, no, the button, you press the button and,
How about that one
there
there?
you go.
Does
Now
that
you're
work?
good. That's it.
All right. I'm Ralph Creston, New Hampshire Towing Association. I'm the president of the association. The association's opposed to this bill. We can't afford this bill to do tows from what that bill was designed for, and I understand it's gonna be dropped. But our personnel costs too much money, the trucks cost too much money, the insurance costs too much money. Everything has just gone crazy, as everybody well knows at this point. So we really can't afford to do this kind of towing for the price that was on that bill.
Great. Any questions? Seeing none, thank you very much. Chair will call on Devin Carlos. Or Keikos? Keikos? Hi. Yep, you hit the button. There you go.
Hi, good morning. My name is Devin Karkos from New Hampshire Towing Association. I'm a director, and I'm from Bob's Automotive in Dover. We are opposed to the bill for pricing, as Ralph mentioned. Most of our drivers are paid on commission based on tows, sometimes day and night, and it would be unaffordable and unobtainable to get drivers to be able to handle these type of calls for that situation. And as Ralph mentioned, with insurance and other costs increasing, it would probably limit the amount of companies doing that. One side effect would be a lot of property management places not being able to get cars dealt with, and having to move cars for like snow and ice removal reasons. It probably would see a big downturn in having towing companies be willing to take this on, and not be able to get parking lots cleared for safety reasons afterwards, because we just couldn't handle it for those prices and those circumstances.
Fair enough.
So, thank you.
Thank you. And one more card left, Bob Clegg, New Hampshire Towing Association.
Chairman, I'll forego anything because I think you've got the gist from everybody, including the sponsor.
Yeah, okay. All right. The blue sheets, we had a bunch of people who are all opposed to it. And overnight, there was 2 supporters for this bill overnight. And the rest were, 3 were opposed. And with that, I will close the public hearing. And just so you all know, unlike other committees in the Senate, this committee does not kill bills the same day. We deserve every bill should have 24 hours. Sometimes little things come up that makes us, want to do something else with the bill and use it as a vehicle. So we generally like to hold it so we don't have to have a non-germane hearing if something were to come up. So. Okay, we'll open up the public hearing on House Bill 1413 and hear from the prime sponsor, Representative Wilbur. Good morning, Representative.
Good morning, Mr. Chairman, members of the committee. Thank you for having me, and thank you for considering House Bill 1413. I'll tell you, this is my, I don't know what it is, third or fourth attempt to try and do something in the realm of internet privacy. My previous iterations didn't come to this committee. They went to the Judiciary Committee because they were framed in terms of privacy in a different way, and so that's where they went. They've been successful in the House and unsuccessful in the Senate for various reasons, which we don't need to deal with. So, having excerpted from other states' laws a couple times, I did it again. And this is basically the Maine law that's been on the books now for 6 or 7 years, and according to my information has been challenged in federal court and has stood, although it hasn't gone beyond the district court level. So, this bill attempts to provide a degree of privacy to you as an internet user by going to the provider of the service that you're going to use. So it starts out, and if you look at provider on line 28, the provider means a person who provides broadband internet access service, which is defined in Roman 1 on line 6. And it's any mass market retail service by wire or radio that provides the capability to transmit and receive data from pretty much anybody on the internet. So it's your phone company, it's your cable company if you get internet access through your cable, it's whoever it is if you're dealing through satellite, whoever's providing you the access. That's where this bill is targeted, because they're the ones to whom you are bound. I mean, and you are really practically their slaves in terms of what you do on the internet. Every single thing that you do goes through them, and they have the ability to extract and information from that of sorts that you wouldn't even think they would want or would be of any value, but they turn out to be of great value. Like your location, where you just happen to be at that particular time, because that can be taken and correlated with other people who are in the same place, and we can find out everybody you ever talked to in your entire life, when and where, and probably what you were talking about through other means of stuff that we can get that you do through the internet. So the risk to our, this is kind of like inherent in our privacy. We don't have the right to record other people, tape other people without their consent. We expect, when you're not in a setting such as this, that nobody else has the right to know what we're doing. But yet, this data that's being collected is exactly that. They can know pretty much everything you're doing, when, where, why, with whom, and all of that. So to try and corral that somewhat, this bill says that they can't use the information that they can gather for any purposes except for those which you gave it to them. Right? They can't sell it, transmit it, or even allow access. One of the great, I think, travesties in our systems right now is that the government can just drop a dime and say, "Oh, I want to know everybody's cell phone who was in Washington, D.C. on a certain day, or around the governor's house on a certain time, in a certain time period, right? Or at your house." Oh, no. They know who's at your house, but the government wouldn't ask that, probably. So this bill intends to curtail that at the source where you are entering into the internet, that is the provider. And it includes great exceptions for all the important uses, from lines 16 to 30 on the second page. And I won't waste your time going through all of those, but it's all the ones you would expect. No one's subject to a warrant or to render and bill for services. Right? They can even provide your geolocation in the case of emergencies to certain entities, but always for your benefit. Always and only for your benefit. And it includes a penalty section, as it has to do, which we have elevated to the Attorney General's office to enforce. And the reason we did that is because these are big people that we're talking about regulating. And you and I would not want to go to court against Comcast or any other of these providers. There are some provisions of this bill, like how they protect your data, that does allow flexibility for the size of the provider. So down on lines 33 through 37, on page 2, it talks about implementing security measures and the factors that have to be considered, and one of those is the scope of the provider's activity. Right? So if it's a small provider, then they probably don't have to implement the security measures that, I'll just use Comcast again, might have to do. So with that, I guess I'll take a couple questions. I would like to keep this brief because I'm absent from my committee right now and I'm the clerk, so it makes it hard for me when I'm here.
Okay, no problem. Representative Bealham.
Thank you, Mr. Chair. Thank you for taking my question. Is there there's no fiscal note on this bill. Could you, I don't understand. I mean, it really will affect the Attorney General's office. Can you comment on that?
So I don't derive fiscal notes, and they don't make a lot of sense to me a lot of times. But I will just say that nobody has any idea how many claims might come up or what involvement it might take for the Attorney General to solve this, and so they probably just said, no big deal. Oh, I do have something. I looked at the online testimony on this yesterday, and Richard Head testified that because it creates a new cause of action, the effective date has to be moved out. But you have that testimony from him anyway.
Okay, any other questions? Representative Burrows.
Thank you, and thank you for taking my question. And I'm asking this, I actually don't totally understand about cookies and how they're used, but
yeah, cookies, we're better off eating them. Just say no.
Yeah, I got excited when they asked me if I wanted them. I always said yes. But my question is, and you may not, you may know as much as I do, but I'm increasingly seeing that sites are making you accept cookies before you can use their sites.
Making you accept.
To say that they'll use, they can use your data. And I don't know if that goes to the internet provider or not when you do that. Or is it just on the website that you're browsing?
So a lot of these things, there's a provision in this bill that says they cannot deny you service unless they've made clear and explicit what information they're going to sell, which does not include your personal information. There's lots of other information that's out there, and they have to make clear to you they're going to sell that, which would be the same type of thing, but that they can't deny you service. This denial of service for failure to allow them to put something on your machine that you have no idea what it's really going to do, but they say it's only going to, we'll know when the last time you came and what you looked at. I don't like it. One time I tried a bill that said they couldn't do that, and it came to this committee and they killed it. They have that. Myself, when they ask for cookies, I don't answer the question. I never say yes. And if they won't let me do anything, I go somewhere else. There's another internet site I can find what I want.
Thank you. So you're sticking with chocolate chip cookies.
Of course, it could be Girl Scout cookies.
Ooh, get some of those s'mores.
Okay. Thank you very much. We'll let you go.
Thank you.
All right, so since he was mentioned, let's do Richard Head. And So
Morning, Mr.
nice to see you again, Richard.
It's great to see you again, Mr. Chairman. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. And as the representative mentioned, I did submit written testimony. I have a fairly simple request, which relates to the effective date of the bill. If this bill is to proceed, there's a statute actually that governs effective dates that I referenced in my letter of testimony I submitted. RSA 14:9A is a specific statute that addresses effective dates. And there's a provision in that where if the bill impacts the judicial branch, either policies, practices, or adds or deletes civil or criminal remedies, the effective date should be January 1 of the following year. And I like speaking to big committees because all of you are also submitting legislation. So it's something to keep in mind anytime you are putting legislation forward. I do this probably 30, 40 times a session. So the extent I can reduce that, it's helpful. And the reason is fairly simple. From our end, this is one bill of many, many bills. And so, for example, if a criminal provision is changed or if there's a new civil provision that's added, we have a database that has a line for every criminal action. And then within criminal actions, like for example, if it's a drug case, the weight sometimes affects the nature of what the penalty can be. So there, one line in a criminal statute can have 3 or 4 lines in our database. The same is true with civil causes of action, and this particular bill adds a civil cause of action. So from our end, we need to be able to both adjust our systems, but also engage in training for our judges, our staff, and what have you. So a long-winded way of asking for, if this bill is to go forward, that the effective date be modified to January 1, 2023. And with that, I'd be happy to answer any questions.
We do have a question. Representative Bartlett.
Thanks, Mr. Chair. I'm sorry, I didn't catch your government affairs judicial branch of what?
So the state of New Hampshire court system.
Thank you very much. I'm sorry.
And Richard used to be Brandon's job, and
Will be
so-
following me. You should listen to him carefully.
So nice to see you again.
Thank you.
So now we'll have Brandon Gerd come up. So we got Department of Justice, Consumer Protection Division. Good morning.
Good morning. Everybody hear me okay? Good morning, Mr. Chairman, members of the committee. My name is Brandon Grodd. I'm a Senior Assistant Attorney General, Chief of the Consumer Protection and Antitrust Bureau at the New Hampshire Attorney General's Office. My testimony this morning is limited to the last section of this bill, which, if effective, would be RSA 359T9, which is labeled Penalties and Enforcement. So as the sponsor indicated, this bill anticipates putting this new statute in the hands of the Attorney General's Office for enforcement. It does not indicate a specific bureau that would enforce it. However, given the nature of the legislation, I suspect that it would likely fall to the Consumer Protection Bureau, as it is essentially a consumer protection issue that it's addressing. So as the potential enforcer of this bill, I think it's incumbent on the Attorney General's Office to point out that the way the penalties and enforcement section of this bill is currently drafted would render it essentially unenforceable at all by the Attorney General's Office, and I'll explain why. For the Consumer Protection and Antitrust Bureau, our authority to investigate potential violations of law largely comes from RSA 358A, which is the New Hampshire Consumer Protection Act, which makes it unlawful to engage in unfair and deceptive acts or practices in the course of commerce. And if something is either specifically labeled as an unfair and deceptive act or practice in the course of commerce or fits that general definition, the Attorney General then has the ability to compel live testimony of witnesses, to compel documents, to conduct an investigation in order to determine whether a violation has actually occurred. And if through our investigation we're able to prove that an unfair and deceptive act or practice has occurred, we then have significant enforcement authority. Civil or criminal penalties are on the table, injunctive relief, fines, potentially jail time if it's a criminal case. But the way this is currently worded, nothing about this puts a violation of this statute specifically under New Hampshire's Consumer Protection Act. It does not make it an unfair and deceptive act or practice in commerce, does not specifically say that it'll be enforced under the Consumer Protection Act. So therefore, the ability to issue a subpoena to compel testimony to enter into an investigation, assuming we receive a complaint of this, we would essentially have no authority to compel anything from the business, which is obviously problematic when, as the sponsor noted, you're dealing with large corporations such as Comcast, Verizon, companies that are not exactly going to show up as a willing participant to sit down and engage in a voluntary interview with the Attorney General's office to determine whether they violated New Hampshire law. So I suggest that, the way it's currently written, the way I would see it playing out is a consumer could come to the Attorney General's office and say, there's been a violation of this statute, I'd like you to enforce it. Our ability to investigate would essentially be limited to what the consumer was able to provide us and what the business was voluntarily willing to give us. And that's not really an effective way for us to enforce a statute like this. I think that if this is to go forward, there needs to be serious consideration about how the Attorney General's office is going to have the authority to do a meaningful investigation of complaints when they come in, because right now, the way it's written, I really don't see that we'd be able to do the level of thorough investigation that we do whenever we receive consumer complaints. The second issue that I'll point out is that this statute, in terms of penalties and enforcement, limits the available tools to the Attorney General's office as a $1,000 fine for a violation. Under the Consumer Protection Act, an unfair and deceptive act or practice is punishable by a fine of up to $10,000 per violation, as well as the ability to receive injunctive relief and the ability, like I said, if it's a criminal case, to impose jail time. And the Attorney General's office retains that discretion based on the investigation, the level of the conduct, the mental state of the bad actor, how many complaints we received, to have all those tools in our toolbox to enforce the statute and really seek justice to ensure that the bad actor, A, doesn't act this way again in order to protect consumers, and B, is punished on a level consistent with the bad action that's taken. I would suggest that the ability for the Attorney General's office to impose a civil penalty that can't exceed $1,000 likely would not do much to deter large corporations like Comcast, and would really bootstrap the Attorney General's office in a very, very limited enforcement authority to be able to do anything about potential violations of the statute. Essentially, it would allow corporations to simply make this go away by paying a fine, and a fine that really, in the grand scheme of things, is significantly less than the fine that the legislature has anticipated as appropriate for violations of the Consumer Protection Act, $10,000 per violation, and as you know, significantly more if it's a private right of action brought by a citizen, depending on the mental state of the company. So I think that if this goes forward, I would encourage the legislature to consider whether it makes sense to keep this as a $1,000 fine or whether it should be expanded to allow the Attorney General's office to use its discretion in seeking appropriate injunctive relief. Certainly, this wouldn't even give us the ability to get a court order, an injunction to prevent the conduct from happening in the future. This would simply allow us to take a fine. And the final issue was pointed out, this ascribes a new responsibility to the Attorney General's office of the type that we have not previously seen before. There was no fiscal note done, so if this is passed, it raises the question of additional resources. We don't know how many complaints we would receive. We don't know how difficult or time-consuming these investigations would be. So it's an indeterminate fiscal impact at this point, but it is likely to significantly increase the number of complaints that come into the Bureau, and that very well may pose the need for additional resources if this is something that the Attorney General's office is asked to enforce. That's pretty much the synopsis of my testimony. If there are any questions, happy to take them at this time.
Any questions from the committee? So, humor, because it is true, I've never seen this, paid much attention to the penalty. To negotiate and to settle with suspected violators without court action. Have you ever seen that before in any legislation? That
So, I have not seen it in legislation. It's certainly not present in any of the statutes that the
Right.
Bureau currently enforces. Currently, if we want to impose a fine, it would have to be done either through a civil complaint and a consent judgment that settles where the fine is agreed upon, or file a civil complaint, go to trial, receive an order from the court requiring the company to impose the fine, or it could be agreed upon through what's called an assurance of discontinuance, which is a tool that's anticipated under the Consumer Protection Act that allows us to settle with an offending business or individual. Not really, it's filed with the court, so there is some level of court involvement, but it doesn't have the same court approvals that are necessary for a civil complaint and consent judgment. But no, language like that is not something that we see in the statutes that we enforce. I haven't seen it.
First
in the
time I've ever
legislation.
seen it. Okay. Any questions in the committee? Seeing none, thank you very much.
Thank you.
All right, Chris Gilrayne from TechNet. Good morning.
Good morning.
Can you spell your last name so we make sure we get it right?
Sure, yeah, it's Gilrein. Thanks for
Thank
the
you.
opportunity to testify. My name is Chris Gilrayne. I'm with TechNet. We are an industry organization representing a wide array of companies throughout the innovation ecosystem, from internet service providers, autonomous vehicles, cloud computing, clean energy, and more. The one thing that really unites all of these very disparate industries is an interest and a stake in data privacy. Our members place a high priority on consumer privacy, and for that reason, we are investing significant time and resources into advancing a federal standard that would have clear rights and responsibilities when it comes to consumer protection and data protection for all Americans. Whether we like it or not, there is no Internet of New Hampshire or Vermont or even California. There is a borderless ecosystem, and privacy laws should be handled at the federal level in recognition of that. Fortunately, in the case of HB 1413, the specific data and practices that this bill is seeking to restrict the use of is already well protected under a number of federal standards, beginning with the FTC standards, the Federal Trade Commission, and a patchwork of other federal privacy laws, including COPPA, the Controlling Assault of Non-Solicited Pornography and Marketing Act, New Hampshire's own security breach and unfair practices laws as well. Our concern is that the broad restrictions in the use of consumer data could throw into question a wide range of everyday processes that underpin the customer experience here in New Hampshire. Combined with a private right of action, the broadness and vagueness of some of the language here could cause a significant liability risk for companies, particularly at a time when the federal money coming in is allowing these companies to focus on expanding their networks, expanding the infrastructure, and connecting more Granite State residents. That should be the focus, is connecting residents as opposed to being concerned about potential massive liability. And that is a significant concern, particularly when we pair it with a private right of action. We've seen it in a number of states. Privacy laws are complex and open to interpretation. And when it's paired with a private right of action, we've seen in Illinois under their biometrics law, in California under their privacy law, a lot of settlement-seeking behavior that really benefits nobody but the plaintiff's bar. To that end, I'll wrap up. I know there are a lot of people behind me, but I appreciate your time.
Great, thank you. Do we have any questions? Seeing none, thank you very much. Oh, Richard, yes, Representative Abel.
Thank you. I just wanted to make sure I understood you correctly. Did you say that there are federal laws that already cover this? And if so, could you just tell us a little bit about that?
Yeah, the main umbrella is the FTC standard, but when it comes to specific pieces of data that are called out in the bill, particularly when it comes to the information of minors, that falls under COPPA, and geolocation data already covered. And so the FTC is the big umbrella, but there are other specific laws that cover some of the specific information that's delineated in the bill.
Okay, great, thank you. Chair will call on Nancy Levin from Washington, D.C. Just so. Good morning.
Good morning. Thank you. I think my testimony is being distributed right now. Well, good morning, Chair Hunt, Vice Chair Patusek, and distinguished members of the committee. Thanks for the chance to testify today. My name is Nancy Libben, and I'm a partner at the law firm of Davis Wright Tremaine, where I co-chair the Technology, Communications, Privacy, and Security practice. Before private practice, I was the Chief Privacy Officer at the U.S. Department of Justice, where I was part of an interagency task force that developed a framework for consumer data privacy in the 21st century, which has been supported and implemented by Democratic and Republican administrations. I am here today on behalf of NCTA, the Internet and Television Association, which is the principal trade association for the U.S. broadband and pay television industries. I want to start by commending the committee for examining a very important issue and very complicated issue of consumer privacy. HB 1413 is well-intentioned, but it is problematic in a number of ways, in large part because it diverges from the well-settled approach taken by the Federal Trade Commission on a bipartisan basis and virtually every other existing privacy regime. The FTC framework was designed to protect consumers and preserve companies' ability to innovate and provide their services. The approach in this bill would undermine both of those goals and would have a number of unintended consequences, some of which I'd like to highlight for the committee today. First, the bill does not cover all commercial entities in the online marketplace that handle personal information. It covers only broadband providers, which have a strong record of protecting their customers' privacy, and does not regulate edge providers such as search engines, social media networks, mobile apps, or companies that collect, use, and disclose large amounts of consumer information like data brokers and online ad networks, leaving these other entities free to use consumer internet browsing history, real-time geolocation information, and so forth to target ads and for other purposes. It therefore fails to protect consumers in the area where their privacy is most at risk. Nor does the bill explain how consumers would be protected against mishandling of personal information by third parties that receive personal information. That is precisely what happened in the Cambridge Analytica incident a few years ago that sparked much of the concern about these issues over the last several years, yet the bill fails to address that. The bill also would impede legitimate business activities. It treats all personal information, regardless of that information's sensitivity, the same way, requiring companies to obtain express, affirmative, opt-in consent before using, disclosing, or making available such information to any person, regardless of and without exception for the consumer's expectations or the context in which the personal information was collected. But not all data, if misused or wrongfully disclosed, has the same potential to harm consumers. A social security number or health-related information is not the same as a device's IP address, which is why the FTC's privacy framework and virtually all other recently enacted state privacy laws in California, Colorado, and Virginia, and even the European Union's rigorous general data protection regulation apply different levels of consent to sensitive and non-sensitive data. In addition, broadband providers, like other companies, typically analyze information regarding the use of their services to improve those services and to develop new products and services. They also use such information to protect their networks from bad actors. The FTC recognized that these activities were consistent with the context in which companies collect information from consumers, and that consent to engage in those activities could therefore be inferred. This bill, however, would require providers to get opt-in consent from customers before using their information for such purposes. This could actually harm consumers by, for example, depriving them of offers for discounted prices or other ways to reduce their costs, and it would impair innovation by depriving businesses of helpful information that they need to design and improve their products and services in a way that appeals to consumers. Other provisions of the bill are unworkable for companies. You will hear later this morning about how pervasive encryption of internet traffic makes consumers' online activity largely invisible to ISPs. This is by design, and it's an important security protection that has been developed over time. Yet this bill would make ISPs responsible for obtaining consent before making consumer personal information available to other entities. This would be an impossible task without undermining the very security protections that have been put in place to protect consumers. The bill also applies to any individuals located in New Hampshire, but the companies won't always know where consumers are located. This will require companies to track the location of individuals to determine whether the law applies, again, undermining rather than protecting consumers' privacy. Moreover, the use of precise geolocation information is prohibited under the bill, absent express affirmative consent from the consumer or when it is used for one of several emergency purposes. Providers would not even know from whom they would need to obtain consent because they would be precluded from using the location of their mobile customers for this purpose. In addition, the definition of customer personal information is overbroad and appears not to have any limiting principle. It can be read to capture any information from a customer's use of the internet access service. This potentially includes virtually all information that broadband subscribers generate when they use broadband services, including data that doesn't identify and can't be linked to a specific individual. The bill also allows consumers to direct providers not to use, disclose, or make available information that is not customer personal information. In combination, these provisions would actually preclude providers from offering services to their customers. Of course, I'm sure that's not the intent of the bill, but that is how it currently reads. In addition, the bill prohibits companies from making consent to use and disclose personal information a condition of providing a service. But ISPs need to use and disclose personal information to third parties in order to provide their services. For example, ISPs must disclose IP addresses when they deliver emails. HB 1413 will provide consumers with no protection against the misuse of personal information by social networks and companies like Google that, as the headlines, government enforcement actions, record fines, and widespread litigation, both here and abroad, have shown are the biggest drivers of public concern over online privacy. The result will be consumer confusion and frustration as consumers learn that the rights afforded to them in this bill offer them no protection against virtually all other businesses operating in New Hampshire online, including the largest abusers of their personal information. Finally, an identical law currently in effect in Maine is the subject of litigation on the grounds that it violates the First Amendment of the U.S. Constitution. At issue is the very approach that HB 1413 takes here, namely the regulation of the use and disclosure of data by one category of speaker, ISPs and ISPs alone. Discovery and briefing on the merits in that case is underway, and a decision is likely to be issued later this year or early next year. At the very least, we ask that New Hampshire defer its current process regarding this bill until the Maine case has been resolved. Thanks very much for the opportunity to testify today. I'd be happy to answer any questions that you have.
Seeing none, thank you very much.
Thank you.
Okay, Chair will call on Maura Weston and Brian Scriber, representing New England Cable and Telecommunications Association.
Good morning, members of the committee.
Yeah, come on, you have to talk, because you got a really good mask there. You got to talk louder. Thank
Can you hear me, Chairman Hunt?
Yes, now that's great.
Wonderful, thank you. Good morning, my name is Maura Weston. I'm here this morning on behalf of the New England Cable and Telecommunications Association. Our members include BreezeLine, formerly known as Atlantic Broadband, Charter, and Comcast. Our members are the leading broadband and communication providers in New Hampshire. They serve approximately 485,000 customers and offer services to more than 650,000 locations in more than 184 communities. We are testifying today in opposition to House Bill 1413. As drafted, the bill's privacy protections are targeted only at internet service providers. As you've heard, this is neither legally permissible nor effective. If the goal is to protect the privacy of consumers, this bill will not achieve that goal. Most importantly, the bill fundamentally misunderstands the role of ISPs in the modern internet ecosystem and when and where consumer data is accessible. On behalf of NECTA, my goal is not only to share with you our broad concerns about this legislation, but to ensure that you have access to the expertise in this subject matter. So with that, I'd like to introduce you to Brian Scriber. He is a distinguished technologist and vice president of security and privacy technologies at Cable Labs, which is a not-for-profit global innovation and R&D lab for the broadband cable industry. So we thank you very much for your attention, and after Brian gives his remarks, we're happy to answer any questions.
Good morning, Chairman Hunt and distinguished members of the committee. As Maura introduced, I'm Brian Scriber, and I am a professional nerd. So I keep your secrets safe, is what I tell folks. The work that we do at Cable Labs, as Maura mentioned, is very focused on security and privacy of subscribers when they are online. And I'm going to talk today about some of the technologies that are in place and how technology has changed in the last 15 years to create a very different environment from the kind of, I think, mindset that came into play for writing this bill. And the pieces of when we start talking about the deck that I think now everybody has the deck that's come through. So the House Bill 1413 lists 9 categories of information that the bill wants ISPs to protect. The handout explains technological capabilities of ISPs to access each of those categories. For many of the listed categories, ISPs can neither see nor protect or do anything with that data. And that is by design. The security in place, the HTTPS, when you on the browser see that lock icon, when you are online, that is a relationship between you and the endpoint. The ISP does the job of moving bits across the wire, but we don't see the encrypted data between you and that website. And that website that you visit can have information, can have scripts that run that advise other websites about who you are and what you did on previous websites. That is information that is completely invisible to the service provider that is doing the job of carrying those bits across for you. So I wanted to make sure if there was one thing that I helped the committee understand today is technology has changed from when this may have had some more sense to its applicability. Today, that encryption and the invisibility of your interactions online to the ISPs make this a step backwards, and it puts the ISPs back in a spot where we have to start cracking open things and working to try to figure out how your interactions online could better be protected. That actually is, like I said, I think a step in the wrong direction for how we want to do this. So the security and privacy technologies team at Cable Labs, how do we get people more protected? How do we get you more encryption? And how do we get there? 98% of consumer time online is over an encrypted channel. That is a tremendous change from where we were 15 years ago, when you were looking at about 30% of that traffic being encrypted. There has been a massive upswell in the adoption of HTTPS, of messaging services. These are all protecting the transit layer. So the ISP that carries that traffic, all we see are very random looking bits that we have no ability to dive into. I want to focus for a second on, I think it's slide 5 shows the networking layers. And on this one, they're without diving into a full networking course, there are 7 networking layers. The top 3, the application, presentation, and session layer, that's where, that's how you as a user on the internet interact with things. You're using an application, you're using email, you're browsing, you're going to a website, you're using a messaging service like Signal or Telegram. Any of those activities, where you're on Google, where you're on DuckDuckGo, all of that activity happens in that layer, and then it's encrypted. Everything below that, that's where cable ISPs exist. So this is where the transport, the network, the data link, and the physical layer, this is what we worry about, and how we make sure traffic gets delivered, and it's confidential, its integrity hasn't, so nobody's changed the messages you've sent, and that it's always available. So confidentiality, integrity, and availability, that's where we focus on those lower layers. But the slide before this is slide 4. And on that slide, this is where we dive into the 9 categories of information that we want to protect. And this is, I think, an important one to kind of walk through. If we take a look at the column for cable ISP visibility, there are several of these. Financial information, we never see it, so we can't protect it. We can't see that info. The customer's health information, we can't see it. We can't advise you that you are releasing your information on a website because we don't know what's happening inside that website. The information pertaining to your children, not visible. The content of your communications, what you texted, what you sent, not visible. From a pure technology perspective, when we look at the rest of this, there's some complicated nuance in some of these. And again, I won't dive into the hyper details on this, but customer web browsing history is important to point out. The ISP is not your browser, right? That browser is a piece of software that you install on your computer, and that software, in the case of Chrome, which is the most used browser, that's a piece of software that Google has written and published. So Google's interaction with you at that layer then becomes encrypted, and we don't see anything other than potentially a lookup to see how to deliver traffic. So if you were to go to cablelabs.com and type that into your browser, there's something called a DNS lookup, where we check to see what is, in fact, it's kind of like a phone book, right? You look up a name and you get back a number. Well, that's what DNS does. It says, here's the routing number for cablelabs.com, and then your traffic is encrypted and goes over that. We don't know what pages inside cablelabs.com you were to visit. We don't know what forms you fill out, any of the messaging that happens. So our ability to protect as this bill is written becomes pretty problematic when we're talking about an encrypted exchange. So that's why there's a limited, right? There's some level of information about this that the ISP has that's actually diminishing as DNS itself is becoming encrypted. So that's increasingly difficult to engage in as well. Customer application usage history. For network optimization perspectives and the ability to do, again, some of this lookup, if you are, we may know that you have gone to a site like Netflix and that there's a lot of traffic that's coming down, and we may need to reconfigure the network to be able to optimize it so that that traffic comes down so that your experience online is as positive as it can be. So there's some information. We don't know what you watched on Netflix. We don't know how you interacted with Netflix, but we do know that, hey, there's still a good amount of traffic that we have to deliver to your endpoint from that net endpoint. As far as customers' precise geolocation information, from a terrestrial cable hybrid fiber coax perspective, like if you have Comcast or a Charter deployment, there is a cable that runs from the head end all the way out to your house. And so with that, we do know where we deliver service, but we do not know where you are. We just know this is where we send the bill and this is where we send the bits. So that's the limit of geolocation information that a terrestrial cable company has. As we go down this list, though, there's two other places where there's a yes. Device identifiers, and this is devices that connect to the internet. We do know some information about those devices in some cases. That is to secure that connection. And if those devices participate in DDoS activities or botnets, we may need to advise the home user, hey, there is a device that matches this description. Can you take a look at it, update the firmware, whatever may need to happen if you're participating in a botnet. So it's critical to deliver the service. And so we do have some of that information, but that is for the purpose of delivering secure and private service. As far as the origin and destination internet protocol addresses, I want to spend 1 second on this one because I think it's such an important part of how this bill is written and the protection of an IP address. If you'll take a look in the slide deck, 2 slides later, there's packets and visibility. And on that slide, you'll see every internet packet that gets delivered has a header that looks like this. Part of that header, that source address and destination address, this is just like US mail. And I think it's a great analogy to use when we're talking about how we deliver traffic. US mail has to have the address you expect this thing to get to, and your return address, hey, if something goes wrong, if they aren't there, get it back to me. That is exactly the same model here. And in fact, the analogy does so well that the bottom of this, when you see that data section at the bottom, that is the encrypted data. It's inside the envelope and it's sealed. So in this analogy, the post office can't make sure you're not getting junk mail, right? Because it doesn't know what's inside the envelope. And you have to have this information for the delivery. So with the destination address, I have to know where to carry those bits for you. And with the return address, if there's errors or that site that you gave the information to, how do you get this information back? So I think that I think we've pretty much wrapped up the key parts of this. I think based on some of the other testimony this morning, when we talk about the bad actors, I think it's salient to bring up that is when a user is interacting on a endpoint, a website that is sharing their information. That bad actor, in this case, this is not the ISP that is the bad actor, and saying, hey, you need to go and police all the traffic and find out how this could have happened. It puts the ISP technically in a challenging position of how do I go and solve this problem with technology? And I don't think that's I don't think that's an easy challenge. So with that, I'll wrap up. Thank you again for the opportunity to come and testify with you guys today. I hope if there are questions, I'm happy to take
We
those.
do have questions. Representative Ammon asked for a question first.
Thank you, Mr. Chair. Thank you for coming to testify before our committee. So there are many different layers to this. There's browsers, there's messaging apps that you talked about. There's the Tor browser. I once put in a bill to have our state libraries run Tor nodes. So privacy is very interesting to me. Could you talk a little bit about, you mentioned the header that goes, that's like the address on the outside of the envelope. Don't cell phone companies, and I think maybe it could be that cable providers do this too, don't they inject something called I think Verizon calls it a Connect ID, that they inject a number into that header so that sites can identify, trace you back to your provider of origin?
So I can't speak to Verizon or their business practices. So I don't know on that front, on the technical side, how to address that.
Okay, I mean, this is a pretty common thing. So if you have T-Mobile, AT&T, Verizon, you can go in, you can opt out of that marketing ID. And if you look at the data coming across the wire, you can see that if you're not opted out, you'll have that ID injected into it. If you opt out, that is supposed to go away, and I think it does. So anyway, that's one way that ISPs can track you, but there are lots of things that ISPs don't see. I agree with you on that. A customer can use a VPN, for instance, right? And that would shield a lot of the data from the ISP. At that point, wouldn't even know what your endpoint was with you. Is that correct?
It would know the endpoint of the VPN, right? So you're still asking the ISP to deliver traffic, but yes, obviously VPNs are one of the options that are available to consumers. It's an additional level of privacy on top of the confidentiality and integrity provided by DOCSIS, which is the cable, again, hybrid fiber coax realm, where we offer security of that communication. VPN adds another layer to that. You brought up Tor. That's yet another layer on this. So consumers have the ability to continually obfuscate that technology. And as I mentioned in my testimony, DNS is also going through an encryption. So we have something called DOE, which is DNS over HTTPS, and DOT, which is DNS over TLS. Two different methods of encrypting DNS traffic, and that's available to consumers as well.
Okay, I agree. You're a nerd. Okay. Representative Herbert.
I have a technical question too, and that is that I've been watching these TV ads where a guy's showing up at everybody's mailbox, and while he's pretending like he can read anything in your mail, and then he says over his back as he leaves the yard, they can see everything you do. And the ad is running on TV, I think it seems like 1 an hour. And so do you know what the hell that's all about?
I'm sorry, sir, I have not seen that ad. I may be in a different TV market than you.
Well,
but
the reason I bring it up is because you mentioned post office and made a connection between how the postal office, delivers to your address. your information and all your mail, and then he turns around and says, oh, by the way, I can read all this mail anyway. And that's what the ad says.
Would
And
you
I
believe?
forget what they're trying to sell.
Would you believe?
Would you believe? I'm seeing this ad, and I have no idea what it's about.
Representative Herbert, I will say that when we talk about encryption and the confidentiality that encryption provides, there's actually two things that happen in common encryption, where there's actually encryption and some checksums to make sure that both confidentiality and integrity of your messages is guaranteed through delivery. Once that's encrypted, without having a key to one of the sides of that encryption, if it's shared, or having the recipient key if you're looking at reading it, without those keys, you cannot see what's inside encrypted traffic.
So the take home here is make sure there's that lock, and it's locked.
Got away with $17 billion.
All right, thank you very much.
Thank you. Thank you, committee.
We'll switch gears here a little bit. Jason Hennessy, who is in support of the bill. Good morning.
Well, good morning. Well, my name's Jason Hennessy. I'm here representing myself. I'm from the wonderful town of Amherst, and I'm here to enthusiastically support HB 1413. So, in terms of my qualifications, I have over 15 years in the computer industry, about 10 years as a researcher, completing my PhD in computational sciences and statistics, and 4 years postdoctoral studies in computing topics at Boston University. I've published researchers in widely respected peer-reviewed venues on related topics, including security, privacy, and system-related topics in modern computing technologies, including a few that have received some media attention. And so I want to talk a bit about this bill, and I thank you guys for listening. So HB 1413 basically codifies what most of us expect when you buy internet service. You're not expecting them to capture every website you go to. You're not expecting them to sell your location, for instance, if you have one of these things. There's evidence that at least as of a couple of years ago, your location information was being sold, and that's not affected by the location toggle on your phone because they have to know where you are based on the towers. Having this information all collected together, remember, it's not just you, it's everybody. And so they know, so it's possible in these databases that were being sold to whoever had a credit card, I suppose, it could be used to, for marketing. But that's one of the most innocuous uses. Imagine a stalker. Imagine somebody who's a political rival having access to all this information. And that's just location privacy. I want to address a little bit of what I just heard the gentleman before talking about. He talked a lot about encryption, and I'll just say that is part of the story, and there's a bit of stuff he left out. So ISPs like Comcast or Verizon or whoever you have the ability to track which sites you go to, even with encryption. It's turned out that metadata, which is the data that talks about who you're talking to, which sites your device is talking to, that actually has a large percentage of the usefulness of even the unencrypted data. And the fact is that the ISPs can tell which sites you're going to because there's a thing called SNI built into the encryption, which actually reveals which site you go to. So for instance, if you go to pancreaticcancer.com, these ISPs know that. And I want to address Representative Ammon's question on tracking IDs. It turns out that these ISPs, there's nothing right now that I know of that prevents them from selling which IP address you have. So whether they insert an ID or not doesn't really matter. If this information is on the open market, just like the location information is, it doesn't matter. That information is all out there. in addition to that, there's a lot of peer connections, peer-to-peer, so like computer to computer, that reveal who you talk to, even in encrypted protocols like Signal. So in addition to that, when they said that you don't know, that the ISPs don't know what you watched on Netflix, the literature has at least been out there for a decade that there are these things called side channels, which can look at an encrypted stream and figure out with pretty good certainty what you actually watched. And this isn't just theoretical. I actually had a research project with high school kids who actually replicated that, and they were able to get a publication out of that. But the basics have been there for years, at least a decade. And so this bill is actually very, very targeted. It only targets the ISPs. And you heard other people talking about, well, you know, there's Google and Facebook and all these things. Well, those are optional. You can get by in society without using Facebook or Google. I try to. But the fact is, you cannot operate in this society without having internet access. You know, if you don't have a cell phone, if you don't have home internet, you can't do things. You can't even do the legislature stuff, right? You guys are on the email all day. I don't know how you keep up with it. God bless you. But but you can't do that without getting on the internet in the first place. So this bill is very narrowly targeted at what society needs. I mean, there's even people who say that internet access is a human right, right? And if we can't get on without being completely monitored where we go, then, you know, how are we going to function in a society when the people who hold this data, you know, start working against our interests? So I want you to think about that. Also, you know, in terms of the location information, at least as of 2019, all of the major wireless providers were selling it to intermediaries. And this wasn't just a theoretical, oh, they might get ads or something like that. The reason we figured this out is because there was a county sheriff who was using this to keep tabs on like people like judges and state police. Now, thankfully, he was caught and convicted, but you know, how many people, like, if you can just get this information, like, what else is going on with it? And what do we not know? When this practice came to light, the mobile company said that they would end it. And at least as of a year later, they did not. There was an article, I plan to send you guys talking about this. And I can just say, I personally checked, they had, one of these location reselling sites actually had a site you could go to and look yourself up. And so I did that, and I actually saw myself. It showed me just where I was with the location turned off and everything. Take this a step further. Somebody figured out that site had a bug in it, a security bug, and you could look up anybody in the country without them knowing. So anybody in the world could have just taken a phone number, plugged it in, and tracked that person. Now think about all the domestic violence. Think about burglaries. I mean, this is a real issue, and this bill goes to address the heart of that. The consent that these companies have is buried and obscured, and I would argue that it's not informed consent. For instance, I took a look at AT&T's privacy policy. It was 27 pages. Verizon's is 20 pages. And a lot of times, even if you read the privacy policy, it does not spell out, hey, we sell all your browsing and your location information. You know, it's not very clear, even if you look at it. These companies thrive on a lack of informed consent. So HB 1413 simply codifies the common expectation that these companies are not doing that. I'll also point out, you heard a lot of concern and problems and things like that. I'll point out Maine has had this for years now, and the sky has not fallen last I checked. I mean, I haven't been there recently, but maybe somebody who's been to Maine can tell me that I think you can still get internet. I think it's still reasonably priced. The fact is that they won their challenge at the district level, as far as at the federal district level, so this is past constitutional muster. This bill is basically exactly a copy of that. Thankfully, plagiarism is legal in laws. The exceptions that you see in 359 T4 address pretty much all of the problems that you've heard about in terms of getting information. You've also heard that we should wait, we should pause, we should not do this, we should wait for federal legislation. I'll tell you that the telecom industry spent over $100 million in 2016 in order to defeat the federal protections for privacy and broadband in 2017. I also heard somebody mention that this would only apply to people in New Hampshire, and how are we going to figure that out? Well, I would argue that Comcast really knows where you are because you don't usually change your home very often. A lot of this is pretty basic, and I think that's most of my testimony. And so, if anybody has questions, I would love to entertain them.
Representative Bartlett, did you have your hand up?
Yes. Thank you, Mr. Chair. A lot of you are talking over our heads, I have to tell you that. But one of the questions that came up from the AG's office is enforcement. Do you have any suggestions on how, if this bill were to pass, how it would be enforced?
Oh, thank you, Representative Bartlett. Oh, I would like to point out that that the private right of action is good. The TCPA actually does this, the federal TCPA, where if you get junk calls in your phone, on your mobile phone, or if you get faxes, you can actually take them to court in a state court and enforce it privately. My recommendation would be that you guys make a change to basically step up the penalties to be for the AG's office to be the same as the private penalties, because that would allow the AG's office to sue on behalf of the consumers, which in a lot of times they have more technical expertise and resources in order to do that.
The consumer protection law in New Hampshire is built around restitution, so you would have to show actual economic harm.
So I would argue that the invasion of your privacy is a difficult to quantify harm, and that it is the job of the legislature to quantify that.
Again, that's why we created the Consumer Protection Act created the way it is, because it was just we can't do that. We have triple damages, but you got to show some damage. You got to show some economic harm.
So I mean I guess the question is how much do you value the ability of a person who's fleeing from her ex-lover and is being stalked? Well, it is criminal, but what if they're using these tools to find them? I mean, what's the value of your privacy? And that's why I would argue that rather than needing to do what you classically did, which is show damages, that I think as a society, I think New Hampshire rights. I mean, we just passed a constitutional amendment guarding our privacy, and I would say that in New Hampshire we value it very highly.
Fair enough, Representative McAleer.
Thank you, Chairman. I was very impressed with Attorney Libben, I hope I pronounced that correct, report. In layman's terms, something that I could understand, would you tell me how this bill goes above and beyond what the federal legislation does?
So I'm not an expert in federal legislation. Whenever I look at federal law, it has a million cross-references, and I get overwhelmed. But my understanding is that in 2017, all of the federal privacy protection acts for broadband were rolled back after over $100 million in lobbying. And so, as far as I know, there is no federal protection other than the FTC saying what you put in your privacy policy you have to follow. But but again, these privacy policies are 27 pages or 20 pages. Sometimes they have like legalese terms. The average person, I don't believe is going to read it, A, and B, is going to really understand all the implications.
Great, thank you very much.
Thank you.
I have one more card left, Jake Lestock, who's going to only take 3 minutes.
I'm trying. Yeah.
All right.
Good morning.
Good morning, Chair, Vice Chair, members of the committee. So I'm going to be recapping
a lot of what people have already said, so I'll try and keep it brief. My name is Jake Lestock. I'm here today on behalf of CTIA. We are the trade association that represents the wireless communications industry, and I'm here in opposition to this bill. This bill would put unworkable restrictions on how ISPs or internet service providers manage customer information and would have unintended consequences that would negatively affect the businesses and consumers of your state. We'll start off by pointing out that federal and state law already exists to protect consumer privacy. The Federal Trade Commission already has authority over ISP privacy protections. They have, for the past 20 years, developed and enforced an effective privacy framework that applies to all players within the internet ecosystem. And as was mentioned before, the New Hampshire Attorney General also has ability to address unfair or deceptive practices with relation to privacy through your consumer protection laws. So there really is no gap in privacy protections that the state needs to address at this time. Additionally, this legislation is going to create two sets of rules for various entities within the internet ecosystem. And we have to remember the internet has changed a lot. A lot of speakers have discussed this. I mean, we're not using stationary computers with one ISP. Now we're using multiple devices connecting to multiple ISPs, accessing content from multiple edge providers. So imposing these strict opt-in requirements on ISPs is not going to protect consumer privacy online. In fact, it's going to make a lot of confusion for consumers in your state, as essentially it's going to create these two levels, and they're not going to be able to determine which is which and what is being protected and what is not. So I think the gentleman from Cable Labs mentioned this a lot. There is important privacy protections in place through encryption. Around, I think he mentioned 90% of websites are encrypted, so ISPs are not able to see what you're viewing on those websites. Additionally, virtual private networks were brought up, and when these VPNs are in place, which are available to all consumers in your state, ISPs cannot see even the domain name that you're accessing. So there are important tools that are already in place that can help you with these privacy protections if you feel the need to have more. Additionally, when we're talking about these sweeping and inflexible opt-in requirements on ISPs, it does go against or at nearly goes in at odds to nearly every other piece of legislation or law or framework that is in place in the country right now. And the private right of action is going to put a lot of businesses in New Hampshire at risk of costly litigation when it's likely to have little benefit for consumers in your state. And then finally, as was mentioned before, there is a bill that was similar to this that passed in Maine, but it is still being challenged in the courts. So kind of just wrapped up everything people have said already, but if you have any questions, I'm happy to answer.
We do have a question. Yes, Representative Johnson.
Thank you for taking my question, and definitely learned some new stuff today. Thank you. Can you tell me approximately how much money do the internet and cable providers make every year on selling our privacy? Because I know it's done.
I personally am not able to tell you. First of all, I only speak on behalf of the wireless industry, so there is, I mean, like I said, a very broad array of wireless players within the internet ecosystem, and I'm not going to be able to answer exactly the number of that, but I'm happy to look into it if you want me to follow up afterwards.
Follow-up question?
Further question, may inquire.
What issues are you seeing in Maine that so if this bill is following the Maine law that just passed, what issues are you seeing with Maine?
So, as I said, we filed a lawsuit at the the Maine District Court in 2020, and that litigation is still ongoing. And as was mentioned before, the decision to impose this unique burden on ISPs alone represents discrimination on behalf of the First Amendment. So those are the issues that we're seeing.
Further questioning?
You say discrimination for these individuals. What about the right to my privacy and everybody else in this room and across the state that have their right to have their privacy and not have their information sold?
Yeah, thank you for the question. Obviously, privacy is an important thing, and we believe that privacy issues are better addressed by a holistic approach at the federal level, as the internet is inherently interstate and goes across state lines.
Great. Thank you very much for your testimony. Having no more cards, let's see, Rick Fabrizio from the BIA is opposed to it, and from the overnight, we had three in support and 2 opposed. With that, I will close the public hearing. So the last. I think we can put it. Okay, sorry about the delay for this last bill here. And Representative Suzanne Vale. I'm sure you found that very interesting, all about the, oh, don't you turn your mic off. Okay. There you go, perfect.
Thank you,
Good morning
Mr.
again,
Chair.
I apologize for the delay.
No, that's okay. It was a fascinating bill, to be honest. Today I am here. Good morning, Mr. Chairman and honorable members of the Commerce Committee. I am Suzanne Vale, and I represent Nashua Ward 3 and Hillsborough County District 30. I'm here today to present House Bill 1422, which is an act that will require items containing perfluoroalkyl and polyfluoroalkyl substances be labeled before being sold in New Hampshire. Water supplies have been contaminated with PFAS in New Hampshire, and currently there is a factory that continues to use PFAS in manufacturing and makes toxic releases into the environment on a daily basis. There are several PFAS contamination hotspots in New Hampshire where cancer clusters are being discovered, and folks who are participating in biomonitoring studies are beginning to receive results.
I'm sorry, could you get a little bit closer?
Oh, yeah, sure.
Thank you.
Sorry about that. Oh, yeah, that's better. Get this to work. Okay, how's about, yeah, that's better. There are several PFAS contamination hotspots in New Hampshire where cancer clusters are being discovered. People who are participating in biomonitoring studies are beginning to receive the results, and they are very difficult to interpret. If it were you, you would be glad to be in the study. You would want to stop using PFAS chemicals, and you would want to know where they are and if you have them in your life unknowingly. If you follow the guidance that is available, you know that you have to clean your home very carefully, test and filter your water, and decrease the presence of PFAS in your life in any way that you can. We have, in New Hampshire, passed legislation to set max contamination levels, to extend the statute of limitations to prove injury with PFAS, to test wells, and we have instituted an array of measures that have raised awareness and put the harmed in a better position. But as community members, some of us have come together to educate one another about how to decrease our exposure to PFAS. You have an information sheet that is a printout of PFAS New Hampshire fact sheet, as well as an FAQ that goes with it. And this infographic is a result of a non-legislative act where myself and another legislator set out to find someone to help us teach people what PFAS is and what they can do about it. A committee formed involving researchers at Dartmouth College, New Hampshire Health and Human Services, DES, and CDC, community representatives, and the fact sheet is the result of, I would say, about 18 months worth of work, maybe 2 years. It is a PDF online, and it is hosted at the Dartmouth Medical School website. It is updated on, I think it's a 6-month basis. And I have sent that to you in an email so that you would have the dynamic document where you can click through and get to the resources. At the end of the last year, I looked at all of our legislation, and I visited saferstates.org website to see how New Hampshire is doing in terms of its striving to be a safer state in terms of PFAS. And I was happy to see that we are considered to be a safer state and that our efforts have been listed there, and including this effort, which goes into the future, and the efforts of other states to try to combat the same problem. There are labeling bills in other legislature in the country, and in fact, the bill, almost all of the efforts in legislating and educating about PFAS have been designed to empower people so that they can live their life with as little mystery and as many choices as they can possibly make. So when I wrote the bill, it's taken from a Michigan bill that contains the most comprehensive structure that I could find to serve as a basis. I spoke at length with a representative who filed a short form bill in Vermont, and that's where you make a statement of a bill that you would like to study, And if the committee decides to accept it, they work on it and they come up with a bill if they think it's a feasible idea. He didn't think his bill was going anywhere. And I'm not sure about some of the other bills. This is a very challenging bill, and it has some flaws. But what it tries to do is to tell a manufacturer and distributor to label products to be sold in New Hampshire that contain PFAS as such. It is just a warning that simply says contains PFAS in packaging or item and which has been linked to cancer, major illness, and reproductive harm. I've included also in your info packet a couple examples of labels that could be applied after the fact on stock that people already have. And I'm thinking in my mind as I'm writing this bill that someone wants to buy a set of pots and pans and they go into the store and they want to look at the label and see, does this nonstick pan, was it manufactured with PFAS or not? Is it going to raise my exposure to PFAS when I'm cooking? So, back to the bill. I think I heard the word Teflon. Yes, we're talking about Teflon and Gore-Tex and anything that has waterproof coating. We're talking about the inside of food packaging where it's slick and nothing sticks to it. We're talking about Glide dental floss. We're talking about waterproof eyeliner. We're talking about a lot of different items that some of the things are listed in resources that I've sent in your email and also what you have there in front of you. So, I have sent you a few resources, including information in your email on the recent findings on the cancer cluster study that's going on at DHHS for people who are in the vicinity of the Saint-Gobain Performance Plastics in Merrimack. If you are unable to access this file, let me know. It's a big file, so I couldn't email it to you. I had to put it on a cloud somewhere, and then supposedly you're going to be able to view it through your Microsoft Exchange. So, so that's where that is for you. But as again I said, the bill intends to empower New Hampshire families to have a modicum of control over bodily contamination. It is known that all of us have PFAS in our blood. It is thought to be found in the blood of creatures all over the world, in places where these chemicals were never used or created, including at the North Pole. And it is my hope that the committee will examine the bill in light of the foregoing facts and understand that it is an adaptation. There are known barriers to this process. I know one of them is interstate commerce laws, which I know very, very little about. The bill itself, when it was adapted through OLS, it did the definition of department, and I want to say that would be in section 1. It doesn't refer to DES, and so the fiscal note is rather irrelevant because it's not DES that would be the department. In the bill that I adapted this from Michigan, the department was described as licensing and regulatory affairs, and I asked for the New Hampshire complement to that to be listed as the draft. I didn't get the fiscal note or the whole bill back until just before Christmas, so unfortunately there were a lot of things that need to be addressed in the bill. But I appreciate the opportunity to present it, and I welcome any questions. I will do my best to answer them. And thank you, Mr. Chairman.
Okay. Any questions from the committee? Yes, Representative Burrows.
Yes, thank you for taking my question. Thank you, Mr. Chair. My question is this: given the difficulty of enforcing this and the cost to enforce it, there must be thousands of products that have this. I'm wondering, first of all, would this maybe be a good idea to follow the GMO labeling, which is based on the USDA? And secondly, maybe it makes more sense for this to be voluntary, given that there are a lot of consumers that don't want this chemical in their products. I certainly don't. And just like GMOs, we seek out products that have the no GMO labels. Might we do the same thing with PFAS, and it would be a good marketing tool for companies?
Honestly, I think that's extremely innovative, and that's why I bring this bill to this committee, because I hope to have that kind of expertise. I think if it could be a voluntary thing and there were no fines involved, that it would be a far better bill. And I also agree that people want to show you that they're not going to poison you. And people are really becoming aware of the extent of this problem. So did I answer your question thoroughly,
You
Representative?
did. Thank you so much.
Thank you.
Okay, Representative Abels first.
Thank you. Thank you so much for testifying, for introducing the bill. I noticed in one of the sets of material that were sent around that there is an example of a label that says, that indicates that the state of California has decided a particular product contains particular dangerous materials, and it reminds me that we've had bills in the past where there were substances in furniture and so forth, and in one case there was a decision to say that if the state of California had declared something in the furniture, that New Hampshire would use that as its way of regulating it, figuring that that's a big market, we're a tiny market. My question is, how could we do labeling so that a manufacturer didn't have to have 50 different labels for each state who wanted it a different way, but we could make it as easy for them to do it, and what your thoughts are on that, and perhaps in amending this bill in some way?
Thank you for the question, Representative Abel. I would be extremely open to having amendments to the bill that would include that type of to me, it seems to be a very, very solid idea that, and I don't know if we would do that, but I would imagine that we would say, if it's labeled for California, it works here. But I'm not sure exactly how we would do that. And I think if the label meets the requirements, which are very simple in terms of what's in the bill, then it fits. It does not have to be New Hampshire specific. I'm not sure how we would get there from where we are right now with this bill.
Representative Johnson.
Thank you. Thank you for taking my question. So I know that you sent us this information and you listed some products that have PFAS in it. We heard a bill earlier this session, and there is a lot more items than what you listed, and I've got the list here. Electronics, alternative energy, aerospace and defense, automotive products, healthcare products, semiconductors, pharmaceuticals. There are so much more than what you have indicated. And so my question is, I really think that how do we get all these manufacturers from all these different industries for just New Hampshire? And because New Hampshire is New Hampshire, we're not California. And I worry about New Hampshire. I don't care about California.
Thank you for the question. I'm having a little difficulty parsing the question.
Well, then we'll leave it as a would you believe.
Okay, thank you. There are literally hundreds and probably thousands and thousands of things that contain PFAS, and I think we need to start. But I do think that we have to remember that we are in a global market almost all of the time, and that when things are manufactured, all kinds of labels are put on them, and the manufacturers seem to be able to know where they can sell the items and what has to be on them.
Fair enough. Did you have a question? Representative Petrusek.
Thank you. I'm going to kind of play devil's advocate. Say this bill did go through and pass, and virtually everything we see, touch, feel, and whatever has a label on it now. I have a cell phone, just like virtually 100% of everybody else in this room, and it has a label on it. What do we do with it? And, okay, it has PFAS. What is that going to mean to me, except it's got a label on it? Could you kind of help me out with that, please? Thank you.
You're going to have a choice. Representative, you will have a choice about what you want to buy. You're going to want to buy the thing that has the lowest amount of risk for you. And if it's an item that contains PFAS, you're going to want to make sure that, a cell phone, I would not be so worried about. I would be more worried about food packaging and like frozen dinners, that type of thing. But in terms of like a stable item that's standing, it's not decomposing, it's not going into landfill, it's not touching something that you're going to eat, it's not makeup going into your eye. We have to look at the kinds of objects that you're looking at to decide where the safety lies for you.
Right. So you're saying we need to pick out those items that are really consumable, or things that we're going to have a high probability of coming in contact with the PFAS product. So you don't
Yes.
expect to put a big giant label on a new car.
No. There's a lot of chips and a lot of PFAS in a car. I'm sure of it.
Yeah,
But
seems
you
like
would
half the parts of them.
you would want it on your pots and pans where you're going to be at the stove, and you know that the coatings on pans wear out, and you can only imagine. I bet some of it goes in your dishwasher and some of it goes down the drain, but some of it you eat. So, and that's tough. So when you buy your pots and pans, you want to know, can I have nonstick, or is it totally out? Do I turn to wax paper now instead of to the insides of these boxes that are coated with plastic that we'll never get rid of? That's going to stand the test of time and be gone long after man is here? No, we want to just do what we can today to make it a longer and better life for the people who are here.
Representative Bartlett.
Thank you, Mr. Chair. Thanks for bringing this bill. You know there's a lot of issues with it, but one of the things I think that's been really, really valuable through this exercise, would you believe, that I think that, until 2 weeks ago, I didn't know that dental floss had PFAS in it. And that's going to go right into my bloodstream. So I think the education value for this bill is tremendous. So don't be discouraged if we kill it, but I think that all of this, whether we're in favor of regulation or not, or labeling or not, are learning about what PFAS is doing. And I think that the conversation will continue.
Thank you so much, Representative. I really appreciate that. And that is really why we're here. We know that the bill has flaws, and we know that it's an attempt, and we know that, it really has some flaws. But I would love it if the committee fell in love with the bill and there's something about it that could just be a single thing that would help. But I really think that, when I come into a committee, this I think is my 4th time presenting a bill that's related to PFAS. And I don't know if that committee knows about PFAS and what they know about it. But by the time you get over to the Senate, you're talking with people, the word is getting around, and that you don't have to start at the beginning of the story anymore. And so I'm really grateful that you already have some experience under your belt, and that you're here looking out for consumers in New Hampshire. So thank you.
I think this committee gets how insidious it is. It's everywhere. So, great. Thank you very much. Chair will call on Representative Wendy Chase. I think you're a co-sponsor? Yeah.
Thank you, and good afternoon.
Yeah, pull the mic
Is
close.
it- okay, how's that? That's good.
We'll learn when we get on the House floor. These mics are really
Yes.
good to be close to.
Okay. Thank you and good afternoon, Chairman Hunt and honorable members of the Commerce committee. My name is Representative Wendy Chase, and I live in Rollinsford, and I represent Stratford County District 18, which is Rollinsford and Somersworth. I am a co-sponsor, and I strongly support HB 1422. And as it was said, we do know that there are a lot of flaws that needs work, but the thing is the awareness and to get the word out that this is something that's put into our bodies all the time, and we should have that option of at least being educated and aware. I did give a testimony. I'm not going to go through everything because a lot of it is stats. I also sent you some documents via the little portal that we have. I wasn't able to print those out, but they are interesting, especially I'm part of the P's study for Pfas. I live in the Seacoast. I received my test results back without any real explanation as to what they meant. My levels are high, but what the heck? What does that mean? How did this happen? So there's, I unfortunately could not print it out, so I'm hoping that you will take the time to just look at that and understand what's given back to the residents that are in the study without any knowledge of what does it mean. Do I tell my doctor? Am I supposed to be aware of things now? What is this health risk, and how did it happen? That's why we want to be able to let people know. So I am very proud to share that my family has lived in New Hampshire for 11 generations, and we resided on the Seacoast for the past 70 years. We have a severe PFAS issue here in New Hampshire and throughout the state. And I do feel very strongly that our residents have the right to and deserve to know where PFAS is found in the products that we use daily. So with the warning labels, again, it could be something very basic, but it's just so that when you pick something up like the GMO and you say, oh, this contains GMO, I don't really want to use it, what do I have for an alternative? That's what we're trying to accomplish or be, excuse me, aware of. So I won't tell you what PFAS is, but it is in here. Since 1960, the FDA has authorized several broad classes of PFAS for use in food containers, substance due to the nonstick and grease oil. So sorry. And the water-resistant properties, as we were just talking about. So they have, some of these been deemed that they're not harmful, but we know that over the years, this does create problems in our blood systems. So to ensure the food contact substances are safe for the intended use, the FDA has conducted a rigorous view of scientific data prior to the authorization for market entry. This includes viewing the data's migration of the food contact substance into the food, expected consumer exposure to the food contact substance, and, excuse me, from this, the other uses in food and potential health impact from the exposure. PFAS that are authorized for use in contact with the food generally fall in these application categories, and I'm really basically talking about the food and what we're ingesting. So we know the non-stick cookware, gaskets and O-rings that are used in food processing equipment. PFAS may be used in the resin in forming certain parts of the food processing equipment that requires a durable chemical and physical. I'm so sorry. I need some water. Processing aids may be used for food contents. And the polymer, what it does is it reduces the buildup on the manufacturing equipment. So again, even though it may not be right in our food, it's being used in the machinery that is processing our foods. So here's a little bit more that's added. It's in paper bags and paperboard. It's used as a grease non-proof agent for wrappers, microwave popcorns. It's in pet food bags. And this gets leaked into our land. It gets leaked into the water and also exposed into the air. So even though the recent efforts to remove certain PFAS from commerce have reduced the likelihood of exposure, some household products and indoor air or dust. Oh, thank you so much. It's been a long morning. Thank you. So some of these products in indoor air and dust may still contain PFAS. So even though we're trying to get this squared away, it is still found. As I mentioned in the beginning of my testimony, I did grow up on the sea coast, Hampton's North Beach to be exact. And there are so many documented PFAS areas of contamination. Northampton and parts of Portsmouth, Greenland have some of the highest pediatric clusters in New England. My daughter, firstborn, was diagnosed in 1987 with Ewing sarcoma at the age of 2. Ewing's is a rare bone cancer, and it's childhood cancer, but it is one of the highest known cancers caused by PFAS. So was it with the water that I drank growing up, the playing fields that I played in my youth? Was it the local eggs, the vegetables, or the meats that I consumed that would have caused my child to develop such a rare cancer? And I'm not saying that PFAS is the cause of that, but it really gives me the food for thought. Yikes. I live in an area with a cancer cluster. This is a #1 pediatric cancer, and my baby was diagnosed at 2 years old. Something's not right. So I also sent, as I said, my PFAS study results, which I would like you to take a look at if you can, because if you can decipher it, please get in touch with me and let me know. I have been in touch with the PFAS study group, explained that I really felt not given the information I needed, and what are you doing to try to help people understand? Do we talk to our doctors? What are we supposed to do once we get these results? Very, very vague information, and I can send you those replies too if anyone's wants to know. So anyway, the bottom line is I don't know. I know I have high levels of PFAS. I don't know where they came from. I don't know what that causes in my health. I'm not the only one. It's something that I really hope that you consider to think about, amend, whatever we have to do to work on this, to be able to let the public know what is actually in the products that they're using, and let them make the choice as to what they want to buy and what they don't want to buy. That's it. I want to thank you so much for the water. I want to thank you for the time. And if there are any questions, I'd be happy to answer. No?
Representative Bealow.
Thank you, Mr. Chair. Thank you for taking my question. Who is ultimately responsible for all the PFAS that's in our waters, our lands, in the air, all over the world?
That's a really tough question. I don't know really where it started, but 3M is a big contributor. It's in Gore-Tex. It's in the Teflon pans. I mean, the ads to help the housewives with this great new pan that's a non-stick, and that was way back in the early 50s. This has been around a long time. It's also in fertilizer, so we know that our animals are getting affected as well. So I can't tell you who. It's everywhere, and it's all over the world.
Just to follow up,
Further question may inquire.
would you believe it's the chemical companies?
Oh, yes, I understand that. I'm sorry, I thought you were asking me. Of course it's the chemical companies.
Representative Greason.
Thank you, Representative, for taking our questions. I think the next bill needs to be, we need to ban the periodic table. More realistically, what kind of manufacturing maybe down in your area that perhaps the residues or the byproducts of manufacturing may be questionably dumped into the water? We had another representative sponsor bill, and there was some manufacturing in his district. It had been proven that they were dumping PFAS, or I think it was PFAS actually, into the water supply in his district. Is there any manufacturing of such like in your district as well that we can narrow the look into? Because to say it's everywhere, so we need to ban all chemicals is not even possible. But if we can find and specify it's coming from here, and if they're doing something illegally or if they're doing something negligently or whatever, that's a whole different issue entirely than trying to slap a label on every single product. So.
Thank you for your question. And yes, and also we're not trying to ban chemicals. That's not what we're trying to do. We're trying to we need them. We're looking to help the consumer understand what they're putting in their body, as we do with other things. Yes, absolutely 100% Pfas Air Force Base. That's where our area of the seacoast has had the most problem, and that, I mean, it's been being looked at, things have been stopped. It's a lot of the foam that is used on the airplanes to put fires out and things, so I would forget what exactly that foam is called. And thank you. And what's happened is it's been used for years and years and years. My dad was stationed there. And it's gotten into the land, it's gotten into our water, it's gotten into our landfills. It gets into our fish, it gets into our oceans. But the other thing is we have Coakley landfill, which is a Superfund spot. So when the EPA came in to clean that up, what they did is they put a cap over it. Well, that great for a little bit, but it's still seeping underneath. So all of what we're finding with that cancer cluster I was telling you in the seacoast area is that Superfund is still leaking, and it's leaking from underneath the cap, and it's getting into the waterways of the developments and the people's houses and homes and wells in that area. So no, we don't have a St. Gilrayne, but we have Pfas Air Force Base. A lot of, excuse me, again, that's where a lot of that research is coming from the Pfas that I talked about. I should have said what it was, because the water is very contaminated. People are sick. There's a childhood learning center there. You know, these are kids that are being exposed and drinking that water for years. This has been going on for years. So that's where the level and the testing is being done at this point.
Representative Burrows.
Yes, thank you, Representative, for taking my question, and I hope you don't mind if I get a little personal, because I know you've been public about this. Does the medical community in New Hampshire believe that your daughter's death, I forget what age she was when she died, was in any way related to PFAS?
Thank you for the question. That's, again, very difficult because there's no way of really telling how she developed that cancer. I was actually just telling Representative Vail I am in a pediatric long-term survivor study right now that's being done through Baylor College and also with Dartmouth Hitchcock. So what I'll be doing next is sending out some of Erin's baby teeth. And they're taking all of this information and trying to see what was it in the DNA, what happened back then. Can we get a little bit better idea of how a 2-year-old would end up with an enormous bone growing tumor? So no, I've even asked her oncologist, and I've asked her orthopedic oncologist too, geez, could PFAS have been there? And it always brings they'll talk about the Woburn area. That was years ago, but remember all the kids, the big cluster. So yeah, nobody can say yes or no, but it's definitely, you know, it makes you think, well, wait a minute. So I cannot answer what caused her cancer. I just have a feeling it could have definitely been a good part of it.
Thank you so much.
Okay, Representative Fargo.
Yes.
You have to pull it pretty close to you.
There, can you hear me?
Closer. Believe it or not. See how close I am?
Okay. So, you know, I think the PFAS is tragic. My husband works for the Department of Environmental Services, so I get to hear pretty regularly about what's going on at a state level and the investigations into the various areas and the difficulty that they're having meeting the requirements or even identifying the potential exposures. But my concern with this particular bill is in the enforcement. because as I read the enforcement, which obviously if we're gonna be able to make progress here, we have to be able to hold people accountable. And I think labeling is a great idea. But there's some things in the enforcement that I really don't understand, like why you may have gone in that direction, because some of it is related to holding a person accountable instead of an organization or a manufacturer, or so I was questioning that. I see that there's civil fines, but if this is, I'm wondering if there's a criminal or consumer protection angle that should be addressed. And the other thing I noticed was that it would be done at a county level, but because PFAS is so extensive, it's got to cross county lines, it's got to cross state lines, it's got to cross international borders. So I don't know how a county prosecutor or attorney general could hold someone accountable. I think maybe it should be at a higher level. I don't know. I'm just wondering where the enforcement component of the bill came from.
Thank you for your question, and so are we. No, actually, as Representative Vale had said, this was based off of Michigan, who has there's a senator who has put a bill in, I think about 4 years ago. I did talk to her about it. It's kind of just in a stalemate right now. So we use that as the concept of what the bill should be. And both of us, yes, we've talked a lot on this, and we've talked to Senator Hassan's office. We've had talks, Zoom calls, trying to just figure this out, because we know this is not just a state issue. So we wanted to also involve our federal representatives as well, and see what's going on at the federal level and try to figure this out. And also, as Representative Vale said, even with Vermont, which is the other state that we know that's trying to do something with labeling, everything's kind of at a standstill right now. And this is why it's awareness. We really want to bring this forward. We'd like to know what needs to be done. You're absolutely right. It's hard, and we sat and scratched our heads like, well, how are we going to penalize this one person? And what about things that are already on the shelves if the law were to go into effect? So I'm going to say it. This is a food for thought. This is something that I'm hoping others will join on board with us, and we'll really pick this up when we rewrite it, we amend it, whatever we do. It's the awareness that this seems to be, in our minds, the next step of letting consumers understand what's going on and not having it in the isolated areas of Merrimack and their water or the seacoast, but it's everywhere. Maine, they're asking people not to eat the deer they kill. They're worried about the fish that are being caught. It's huge. It's getting bigger. It's there. It's the awareness, and we just want to be one of the first to really do something about it.
Great. Thank you very much for your testimony. One more card left. Kirsten Koch from the BIA. Now, I have no card from the department.
Nope.
Unfortunately, good afternoon.
Yes, we have made it into the afternoon. So, good afternoon, Mr. Chairman and members of the committee. My name is Kirsten Koch, and I'm the Director of Public Policy for the Business and Industry Association, also known as BIA. I'm here today to express BIA's opposition to House Bill 1422. BIA fully acknowledges concerns surrounding the contamination of perfluorinated chemicals in New Hampshire's natural resources. But today, my testimony will address the feasibility of implementing this bill at the state level in the business community. BIA believes the House Bill 1422 would be impossibly burdensome for manufacturers and retailers to implement into practice. This mandate would affect businesses in nearly every single industry. This bill is even going so far as to attempt to regulate commerce at a state, regional, national, and international level. House Bill 1422 requires the state to evaluate and regulate nearly every product manufactured for sale in New Hampshire, in addition to identifying violations and enforcing fines. This bill would be especially damaging for New Hampshire small businesses because they do not have the resources to monitor and label the sale of every otherwise legal product in New Hampshire. Furthermore, multi-state businesses need uniformity in law to effectively ensure their ability to consistently apply. So in conclusion, BIA respectfully requests this committee to vote for a motion of inexpedient to legislate. This policy should be addressed at a federal level, and the burden this bill creates should not fall on local businesses nor the New Hampshire Department of Environmental Services. So I thank you for your consideration of our position on this legislation, and I would gladly try to answer any questions you have on this.
Representative Abel.
Yes, thank you. Thank you so much for coming and testifying. Based on an earlier bill we heard, and you may not have been here then, and this one that also talks about the possibility of handling things on a federal level or on a state level. I just wonder if you or the BIA has a viewpoint on what's appropriate to be done at a state level when there's an issue where regulation could be done on both the federal and the state level. I'm just trying to get a sense of what is appropriate for a state to try to do and what is best for the federal government to regulate.
Thank you so much for your question, Representative. We believe this policy should be addressed at the federal level. Multi-state businesses need their uniformity, and you know, it'd be incredibly difficult, if not impossible, for the state to regulate every single product that comes into New Hampshire for sale. I mean, this bill even addresses products that are sold over the internet. And you think about Amazon and how popular that is today. It would be impossible for the state to address that. So that's why we believe that this policy would be best addressed at the federal level.
Representative Bartlett.
Thanks very much, Mr. Chair. Is the BIA, do you even have this on your radar as an issue that's affecting New Hampshire residents, consumers?
Thank you for your question, Representative. Absolutely, PFAS is one of our highest priorities, and we fully acknowledge the concerns surrounding PFAS, and I commend the prime sponsor and the co-sponsors for addressing this topic and bringing awareness to it.
Further question?
Thanks. I just want to follow up a little bit. If it is a top priority, could you give us an idea of what the discussions are and any kind of, other than just saying it's a federal problem, any kind of solution that might be proposed or discussed with your members?
Sure. Thank you, Representative. We believe that PFAS policies and regulations should be set on science-based policy. And generally, this type of policy is best set at the EPA on the federal level, but we're just looking for science-based policy and not just arbitrary measures. So our concern is just maintaining that science-based policy.
Representative Fargo.
Yes, and thank you for your testimony. Yeah, while I agree that this should be addressed at a federal level, I would want to know why you would say that the burden isn't the responsibility of the New Hampshire Department of Environmental Services.
Thank you for your question. Well, it would be their burden, and we don't think it's reasonable or realistic for this burden to belong to just the New Hampshire DES. We believe this issue is much larger than maybe even something they could handle. It should be addressed at the federal level. Something this bill is missing, especially in the fiscal note, is that it doesn't address the cost for lab testing and what it would take to evaluate and identify thousands of products that are for sale in New Hampshire. And we just don't think they have the staff, the resources to possibly even carry out what this bill would require.
Well,
Further question, you may inquire. It does have a fiscal note of 100 grand.
yes.
Further
Follow
question.
up?
Yep.
So my question then is, if you don't feel, what is the purpose of the Department of Environmental Service if not to address chemicals that are polluting our environment? My husband works for the Department of Environmental Services, so I'm finding this a little bit of a stretch for me.
Sure. Thank you for your question, Representative. Let me clarify. We absolutely believe in the capabilities of DES here in New Hampshire. We just think that what this bill requires is so large and so costly that it needs to occur at the federal level.
Okay, great. Thank you very much.
Thank you.
I have no more cards. The sign-in sheet was blank, and or the overnight. We got 7 in support and 2 in opposition. And with that, I will close the public hearing. So we'll do the subcommittees at 1:30. Okay. So, he implied that some states allowed this or something? Did he think that that was true or something in his testimony?
I don't see how it could. I mean, perhaps the state law in another state allows more flexibility, but it still would be preempted by federal law, so it wouldn't help those other states.
Right. So do we have, what do we have now for short-term policies? Do we have anything now?
We do have a company that does offer short-term policies. It's just one though, so there aren't very many out there.
And what's the need? Because I remember one time it was like $10,000 and it
What
was
is that?
limited, it had a very limited benefit to it.
The benefits are very limited. I couldn't tell you what the benefits in the policy that's being sold in New Hampshire are at the moment. I could get back to you, but a lot of people do buy these policies without understanding they're as limited as they are. Even things like, while the New Hampshire insurance mandates apply to these policies, they can do pre-existing condition exclusion. So virtually anything that would have a state mandate they could put in a pre-existing condition and not cover that services for that type of thing. So in general, there have been some national reports put out around short-term policies and some of the consumer dissatisfaction with them. But New Hampshire's experience is pretty limited.
Do you get complaints for people once they realize what they bought?
I'm not aware of any.
Okay. But it's only 6 months now, right? Isn't that policy with
Right.
the nature of the policy we have?
I believe that's true, yeah. Yes, I think it's 6 months with one renewal.
6 months with one renewal. So you could technically get a whole year.
I think that's right.
Right.
I need a shovel.
You shovel? Yeah, well, you got a lot of stuff there.
See what happens when they don't show up?
I'm not on that subject.
Okay. So let's see, who? All right.
John, can I ask Tyler a question?
Yeah.
Can I ask Tyler? Tyler, thank you for being here. We've talked many times in the past about how destabilizing the insurance policies could impact premiums and cause overall premiums to go up in the state because of the inability to have the stability that we need. And we've had this conversation countless times over the last couple years. How do you think this would impact premiums in the long term?
Yeah, so your question is very loaded and right on. I mean, to the extent you could create an opportunity for healthier people to leave the more regulated market, go into something like a short-term policy or an HP, something that has a premium that would benefit them being healthy. You draw those healthy people out of the larger market, and then you're left with sicker people who pay more in terms of their premiums. In this case, because the federal law has certain requirements, it would preempt any sort of state flexibility. So while you could have some seepage, some leakage from the regulated market in terms of the healthy people, it would be less so than if those healthy people had a more permanent option in the short-term policy arena.
You know, when we passed Senate Bill 711, so Paul and I are probably the only ones in the room who remember all that, and everybody else, I think, is missed out on that fun. So we actually passed, the Affordable Care Act long before then it actually became federal law, and the whole debate around that original bill was. It was what was it? What was the company called? Was it Pine Tree or Pineapple, or it was someone that they were very active in the individual market. Golden Rule. That's right. Golden Rule. That's it. Golden Rule. And the rule, the golden rule was as soon as you made a claim, you got canceled. Right. So, the policies were great as long as you never made a claim.
Right.
But as soon as you made a claim, they somehow just non-renewed you. And that really is how we got into passing community rating in the first place. So, assuming in this case, these policies we have now, these short-term policies, which that they violate, they probably have caps, right? Do they have? Do we know the one product we have in this market what the cap is? We
I
don't.
don't.
We
I
don't
apologize. No.
Okay. I'd be interested to know what the one product we have. Do you know the company who's selling it?
I don't remember. I apologize.
You know, Paul? Yeah. Who's the one company that is selling this short-term policy in the state? Yeah. There is one company. Right. Well, I'd be interested to know
Some of the details on it.
I think before we kill this bill, I think we should at least know what's out there
Understood.
and what is there. I mean, obviously, you would argue that you would go Cobra, but Cobra is hugely expensive when you're paying the employer portion. You're paying the employees. So I assume these short-term policies are fairly inexpensive.
They tend to be less expensive, but not. The benefits are not proportional, so the benefits would be much weaker versus
Right.
the lower cost.
Well,
for it.
benefits meaning that they don't have any of our mandates, right?
So
Right.
what's the benefit of putting this off just to have the?
I would like to know if we're going to make a case for why we're not going to pass this bill. I think we need to be able to tell people what is available, what is that short-term policy is. So at least we can articulate that and know exactly what is going on with the marketplace.
Another question from a consumer protection kind of perspective, and sadly, because if you have one of these short-term policies and people aren't educated, like my husband got cancer out of the blue. He was never sick a day in his life. It was just a freak thing, and next thing you know, we're in trouble. And are there any safeguards for people who?
I would think in a case like that, they'd probably consider it a pre-existing exclusion. The safeguards typically are when you lose your insurance coverage, you have access to the marketplace, the exchange, and that's guaranteed issue, and normally subsidized for most people.
That's really the big difference now, even when we passed 7-Eleven, or even when the Affordable Care Act was first passed, was that we now have a very active, thriving marketplace for individuals. It's subsidized by all of us. So the premiums are not as bad as they could be. So it's, and so that theoretically, it basically drives people into the marketplace. Is what if your employer or whatever, you're not gonna, you would not hold out for your next employer, or if you were changing jobs, you would just go into the marketplace. So you really wouldn't even buy one of these short-term policies anyways.
There's not as much demand for it, for sure.
I would think now the marketplace is fine. So for you guys, Representative Terry and Gleason, who are kind of new to all of this, are you following what we're talking about in terms of the difficulties of this the bill, which was to take the short-term policy and try to make it available, which clearly violates federal law. But in terms of what people need to know is that yes, you're supposed to go to the marketplace and get an individual policy. You guys comfortable with that? You understand that?
Yes, I'm generally aware of this, Mr. Chairman, although I wouldn't want to be tested on it right now. Thank you.
So how are you leaning right now?
What's that?
How are you leaning?
Well, I wouldn't pass this bill. No, I would never pass the bill.
Okay.
The question is, whether interim study so we can talk about it or learn about it. But I'd rather let's wait that's late to learn about what the policy is, and then before we decide to say something.
Okay. I think-
Yes, Holly. Why don't you come forward? You have to have a mic. 'Cause I think we're online. I think we're live.
Chairman, just for
Yeah,
the record.
you gotta talk close to these mics. They're very sensitive.
For the record, Holly Stevens, I represent NAMI. I did a little bit of research while I was back there just kind of
Okay.
Googling.
Okay.
The one plan in New Hampshire, or the one company is Independence American Insurance Company,
Independence.
a member of the IHC group, whatever that is.
It's an Independent
American Insurance Company.
Insurance Company. Never heard of them.
They've got a number of different plans depending on deductible amount and out-of-pocket amounts. But the one important thing that I think is worth noting is that it says for every single plan that is listed for me, I put in my birth date and that I'm a non-smoker and that I'm a female, there is no coverage for outpatient prescription drugs for any of their plans.
It has no drug plan.
No drug plan at all. So the one provider in our state does not provide any coverage for prescription medications.
That could be somebody who would want that plan. I mean, you're young. I mean, we're assuming that most people who take these are young people. So, I mean, that they might not want a drug plan. But does it say anything about the premiums? How?
Yes, depending on the deductible amount. Like there's one where there's a deductible of $10,000. The premium is $179.
There you go. That's what you call a catastrophic
but
plan.
I can't tell from here though what benefits are covered.
What they actually cover.
Right. I can't tell if they cover mental health or substance use or maternity or anything like that.
I assume all those wonderful things are not being covered.
I would assume that as well.
Pre-existing conditions.
We're talking about a truly catastrophic type plan.
So I just offered that to you, Chairman, because I found it online.
Right. Great. So what were you thinking?
If young people are buying these policies, is that what's happening?
Yeah. Well, that's who I always thought it was.
Yeah. Well, we should force them into a system where they subsidize us old people, right? That's what we
That
should
is
do.
that is the current law. Yeah. The current law is really built around the idea.
I was making a joke, but
it was tongue in cheek, but yes, that there is no doubt that the whole point of community rating was that, and right from the day one, for the original battle was the age banding. And actually, when we tried, and the age banding now is what, 3.5 to 1?
We did have 3.5 to 1.
3.5 to
3 to
1. So I always said when we tried to revisit the non-group market and the individual market, we actually removed age banding altogether. We actually brought it back. This was under Benson, and I always said the mistake I made at the time was that I just removed all age banding, and I should have left in some age banding, because we absolutely had individuals that came in and said all of a sudden they were paying outrageous amount of premium, and it was because they were the upper end, because once you get 65 you're Medicare. All right, so if you were 60 years old, the premium was I think in this case it was like 12 to 1. It was that huge of a band, and so I always said the mistake was I should have made it 6 to 1, and that maybe it wouldn't have been as bad, and we might not have ended up having to repeal what we did, but. So yes, so the idea is that now it's interesting because I remember New York, they had no age banding. It was one premium for everybody. So yeah, in that case, young people were really subsidizing the old people. But the age banding, you know, obviously was we did at that time. I think we were 4-1, 3-1. Was it? I think it was 3-1, wasn't it, Paula? I think it was originally 3-1. And the idea was that we would at least give some relief for younger people. But yes, it's no doubt in my mind that the nature of insurance in general and the only reason you can call health insurance insurance at all is that we're assuming that healthier people are going to pay the premium because they think they should have insurance, and the reality is they're subsidizing everybody else.
So I have some younger friends, they like to go rock climbing, and they're very healthy, right? So
Right.
if I were them, I'd be worried about falling and breaking a leg or maybe getting cancer, but I wouldn't be worrying about, they're very fit,
Right.
getting diabetes or something like that, right? So
Right.
having them have options, I think, is a good thing
It would be nice, but we can't.
in the real world.
But let me say, the Affordable Care Act doesn't allow that. So,
But there is an option for catastrophic coverage under the ACA. And it's
well, I call the catastrophic is the high deductible. That's
Yeah.
what's catastrophic to me.
It is.
Is that where you're going?
Yeah, it is.
Okay. It's not really catastrophic. It just means you're going to pay all out of pocket until $10,000. I mean, that's huge. I mean, I know as a small group, as an employer with small group, I think the highest, I think I'm paying now. It's the high is $6,500. So the first $6,500 is, but the premium is pretty low. Right. Yeah. So. Okay, so see what you can find out. I'd be interested to know how many people were buying it. Whatever you can find on it, that'd be
Yeah,
great.
we don't have the number of people who are buying it. It's not something that's generally reported.
Oh, you
to
don't
us.
know? You don't know? Huh?
No, we don't.
But don't you guys have to audit this company on a regular basis?
They may submit information through, the company may submit information that is fairly basic.
Okay.
It's part of what we consider a survey, but it's, we're pretty hands-off with the short-term policies.
Okay. Assuming because there aren't too many of them.
And there's not a lot of regulatory oversight in general.
Okay. Need more info on current company. Okay. All right. Next. All right. Relative requiring insurance coverage for vaccinations, devices, medications authorized for emergency use by the United States Food and Drug Administration. Okay, yeah, so this one, did we have any evidence that anybody's been rejected? Or how do we know? I think you sent us out something, right? This is 1162. The question is actually, has there been a situation where somebody was refused?
Nothing in testimony.
Let's see mine. Okay, here we go. Okay, this is Representative Gay's bill. Okay. I mean, we could interim study it just so in case something did come up, if we did find out But passing it just for the sake of passing it, I don't know, does someone feel that we should do that? I like to have less clutter in our statutes. Jeff, have you ever heard of this problem?
The concern, the issue that's brought to mind, the concern of Representative Gay, is to ensure that insurance companies are covering any injuries that are caused by vaccines and medicines that are authorized for use by the FDA under emergency use authorization. Okay.
Right.
If there is a chance or there's a perceived threat that an insurance company would not cover those injuries, you weren't taking that, as being on label, or you take an experimental vaccine or an experimental drug or something like that. So an insurance company may not cover those expenses because it was experimental.
Right.
And so when the making sure that people are covered by those types of injuries. And that was one of the statements that came out during the original hearing, was that the wording is challenging. It just needed to be clarified that that's what the objective is. I mean, that's what I wrote down.
So how would we fix that?
So to clarify, are we talking about the actual experimental service or the problems that might develop from the experimental service? Because if we're talking about the problems, that would be considered discriminatory if a carrier said, well, we're not going to cover that because of something about you.
So they don't have to, it's not about the insurance company covering the experimental drug.
Right.
That's completely different. But an injury that is as a result of that, because remember, it's authorized by the FDA under emergency use. Okay, so it's not a part of a drug trial or anything like that. I don't know how that would be covered. I'm sure there's federal laws that govern that, not that. But just making sure that if you take anything that is authorized under even emergency use authorization, that any injuries that are a result of that would be covered by your insurance company.
Yeah, and it really would be treated like anything else. I mean, insurer wouldn't be able to say, we're not going to cover it because of how, we're not going to cover your condition because of how it was caused. That would be considered discriminatory.
There's been several I don't have it with me, but there's been several studies done and several occasions across the country that this has already happened.
What is this Invectin? What is this, the ivermectin?
So ivermectin is not an experimental drug. Ivermectin's been around for a while. In fact, the person who brought it won a Nobel Prize, okay, for medicine for ivermectin. The problem with ivermectin is it is one of the most successfully used drugs in the world ever, safer than even Tylenol on a drug safety rating, but it has not been authorized for use as a treatment for COVID. Okay, it's been used, but it is not. The FDA has not officially approved it for that use. So anybody who uses it is using it off-label. It's not illegal. It's not horse paste. It is an off-label use, and doctors prescribe drugs for off-label use of all kinds of medicines. It's not an unusual practice, but for some reason or other, ivermectin gets labeled horse paste, and people are nut jobs for taking it. And so anybody who would use ivermectin, according to this bill, ivermectin is not authorized for emergency use authorization.
Because this is FDA, right? So it wouldn't get covered.
It would not, because it's not authorized for use under emergency use authorization. It's already FDA approved.
That's interesting. So that what you're making argument is that we shouldn't pass this bill because I know this statute. This is the off-label statute. And this bill originally, in my memory, was for cancer, wasn't it? It was a cancer bill, is my memory, and it was being pushed by the Cancer Society. They wanted this off-label.
Yeah.
Were you around for that? Were you around for this one?
There have been several drugs that have been developed and experimented and to use it off-label because they found an application in cancer treatment, and that may have been it. I'm not familiar with that particular law, but this would cover, for example, the COVID-19 vaccines that have been used for the last 2 years now, or a year and a half, whatever it is has been, have only been approved under emergency use authorization. So that's what we have on the market today. That's what people are getting now. What was approved by the FDA is a variety that is not even on the market in the U.S. called Comirnaty. And so what you are getting when you go down to the clinic and get your shot is actually authorized under emergency use authorization. So if you experience an injury for that, the motivation for this bill would be if you are injured by that, your insurance company needs to cover that because there's the concern that they might deny your claim because you took an experimental drug.
Can I,
Mr. Chairman?
And we're hearing from the Hospital Association that hasn't happened.
Their written testimony? Mr. Chairman, it seems to me that this bill begs for work, whether it be by this committee, and by the way, Representative Greason and I have just come from a meeting with the Speaker where your method of operation is praised as laudatory and exemplary for other committees, which we already knew, but we appreciated him saying that.
Okay.
In the special regard that this committee actually works on fixing bills that we deem to be deficient or
Right.
defective,
Correct.
in contrast to other committees
Oh,
that
yeah, yeah,
tell
yeah. Oh,
the
yeah.
sponsors to go and fix it, which in this case might not necessarily be the proper course of action unless we want to work collaboratively with the sponsor, because in the written testimony that was submitted on the 2nd by the NHHA, we were told and we confirmed that the analysis of the bill is in conflict with the language of the bill.
Right, right.
In other words, the stated intent of the bill and the language of the bill are contradictory.
Anyway.
So I don't know how much time we want to spend on trying to fix this today, and I don't know whether or not you want to consult with the sponsor on how to fix this, but clearly this needs to be fixed.
Right.
Period. Thank
So
you.
the question, great, thank you. So the question is,
And the compliment, did
do
you
we want to?
appreciate-
Thank you.
you like
That,
that
I
too?
like that part
Thank
too.
you. Good.
All right. So the question is, do we want to try to fix this in the next couple of weeks, or should we interim study it and?
IS.
I agree.
Okay.
IS.
All right. All right. Let me-
You're welcome.
Okay, here we go. So now, all right. So I got the right bill, 1162. Okay, Hunt, Bartlett, Greason, Terry, Burrows, Emmett. Okay, Representative Terry, seconded by Representative Burrows, moves interim study. If you want, I heard somebody over there second.
Oops.
Yes, are you
No,
okay with
have
seconding
to.
it?
I can't.
Oh, no.
This
Oh, no, yeah, she's on it. Fargo is on it. Yeah, right.
I can
Okay.
voice an opinion, but I
Okay. All right. Any discussion on the motion? Seeing none, all those in favor of interim study, please raise your hand. Okay. Unanimous. Okay.
Good, that took care of that. Fix it.
Okay, great. That one's done.
Isn't this a mandate?
All right.
I'm just saying.
Now, I used to joke that other committees, if it's not 99.9% pure, they just kill it on site. And I always thought that it's outrageous because, and then they would say to the sponsor, you go make the amendment. I think, well, no, the bill belongs to us.
Yes,
It's our
Mr. Chairman,
bill.
we've just experienced this in another venue, another committee, and we were in shock.
Shocked.
And furthermore, we were told to fix it, and then we were told to fix it, and then we asked, what are we to fix? And they said, well, you figure it out. This is
I
no
missed
way to do the
freshman-
people's business.
Freshman representative mind reading class that day.
Right, but you went away realizing how fortunate you are.
We are.
To be on this committee.
By the grace of God, I'm here.
Okay.
There.
All right. Next up, relative to co-payment and services rendered by a chiropractor. In this case, we do have a sponsor in the room. You want to come on up and take a microphone? All right. All right. What do you really want? Since we can never really can't get you being paid more.
I think it's very simple.
Hit that button. Hit the button.
Yeah, I guess. Yeah, there you go.
Is it on now?
Yeah.
Okay, I'm sorry. Thank you. Is we want to be delegated as a provider, not a specialist. That reduces the co-pays, and it's all about making it easy for patients to get care. I'll give you a good example. I mean, I didn't realize I'd be having any speaking role today. So I had a new patient come in yesterday, and her insurance checked out that she has a $100 copay. You know, that's insanity. When I see, and we talked about this last week, about how the state has a special plan, the teachers have a special plan. You know, you're talking $5, $10 copays. Specialists on the state and teacher plan are $30. Right. We run anywhere from 40 to 60. Now I saw 100, and
So what plan did she have? What company was it?
You know, I think it was an Anthem plan. Well, I can't.
Right.
I don't know.
Okay. Well, first I want to make sure everybody.
I'm not sure.
Okay. Make sure everybody understands.
Watch your back.
I'm pretty sure it was Independence
American, right?
Yeah, let me change that. Independent America.
Right.
No.
Okay, so
basically that's what I'm looking for. It's not going to cost you know, any patient anything. It's not going to cost the insurance company anything. It's just a reduction in co-pays by taking us out of the specialist category and putting us into the primary care.
Yeah, but everybody has a copay and co-insurance.
No, I understand, but if you're under the specialist copay,
category,
it is significantly higher, and that's what we're trying to do: is reduce it, make it easy for patients to seek care.
Right. Okay. So the one thing I want to clear up, and I'll let everybody speak, but that when you start talking about the state employees and all those other
Right.
plans, those are RISAs.
No, I understand that, but
And-
I'm just giving some
Right.
examples.
And then the other thing I want to say is, as being the person who was in the room when we passed the legislation, original legislation dealing with chiropractic
Right.
services,
Right.
where we said that if you offer it, you got to give 12 months,
Right,
1 a month.
12 visits.
Right.
Right.
That when we passed that, again, the deal was that insurance company, that was if they did offer it. So
Correct.
at that time, Cigna, are they in the room? No, they're in the room. At that time, Cigna dropped it. Obviously, they now carry it because I know she was in the room when we
Correct.
had the hearing. So they now carry it, but that it was sort of like the consequence of the legislation.
Okay, excuse me for just a sec.
Yep.
So I'll give you an example of, I'm trying to think what insurance company, but it's a $50 copay, and we get $3.90 from the insurance company. I just think that's unfair for the patient,
So
because
you-
then they think they've got chiropractic care, and actually they don't.
Right, 53. So you would rather just run the
I'm-
risk of
I'm
them
trying to-
dropping the
I'm trying to get it
chiropractic
so
coverage?
it's a lot more convenient for patients to get in without breaking the bank. Plain
So
and simple.
in terms of this language here, you would, what is the word that says, that would help you on, because all I see is that
I think what would
copay
be
and
helping me on
co-insurance
is you take us out of the
greater than the
specialist
copay.
category and put us into the preferred
Chairman,
preferred
Mr. Chairman.
provider.
So,
All right.
so if that happens, I'm just trying to think this through. If that happened, if that were to happen, the provider is still going to charge X number of dollars. This assumes that the insurance company decides to continue coverage under this change. Okay, that's
Right.
that's point one. The provider is still going to charge X number of dollars. What it means is that the patient is going to pay a smaller portion of the total number of dollars that are allowed under the contract that the insurance company has with the provider, which means that unless that dollar figure is lowered in negotiation between the insurance company and the provider, the actual cost of the provider is going to be greater because they're going to be sharing a greater proportion of the allowable cost because you reduced the copay, let's say, from $50 to $10. Am I understanding this correctly? But that's the implication. I mean, so on the one hand, we're saying that the patient only has to pay $10 instead of $50. But what are the implications for the insurance company unless the insurance company contracts with you or chiropractors to lower the allowable fee, which you then have to determine whether you accept?
Correct.
And if you don't accept it, then bye-bye.
Correct.
I got this?
Correct.
Okay, thank you.
Right, so in this current scenario, you're saying if it's a $50 deductible and you're only getting $3
No, $50 copay.
excuse me, $50 copay, and you're only getting $3.95.
Somewhere in that
That
vicinity.
means, well, let's call it $4.
Right,
That means the total amount of money you got is $54.
right.
Versus if we were to say that it has to be the same as any other physician, which is $10, that doesn't mean they're going to raise that $4.
Well, I think that goes back to contract negotiations then.
Right,
yes.
goes back to the,
Absolutely.
and then at that point they might say
Bye-bye.
Exactly.
that
That's
that we're not going to cover chiropractor anymore. Yes, Representative Johnson, I know you want to speak. Why is your green? Oh, green means too many lights are on. I'll take.
Oh, okay. So I know one of the other things is to be able to offer chiropractic to more people for health benefits. Am I correct? That's another reason why this bill was brought forward, to reduce the cost so people can get more health benefits out of the chiropractic, unless I'm mixing it up with another bill, but.
No.
Okay.
And
I know the insurance company I now have, they switched over because they saw the benefits of chiropractic care. So my insurance company, my health insurance company, took our healthcare, our chiropractic, and took them out of the specialist and made them regular providers. It has done a wonders just for my family alone. We are not seeing the doctors on a regular basis. We go to our maintenance with our chiropractor, and it has saved us hundreds of dollars going to a regular chiropractor, rather than going to a doctor or a specialist, just because of a chiropractic care. And I think, if I remember in the testimony, they also talked about those who have back injury or knee injuries. If they can go to a chiropractor more often, they'll be less likely to get hooked on the opioids and the drugs, which is what we are trying to do in our society, is to help stop that.
correct. Thank you. I'm sorry.
Mic off. Okay. Bartlett, why don't you go ahead? Oh, Fargo.
I have two issues. One, when you, and Tyler, maybe you can jump in here. If you change the copay and you keep the coverage, then the insurance company is paying more than they were paying before because I'm paying less, and that's a drive on pushing premiums higher, correct?
Yeah, and not only would the insurance company pay more for the existing patients that they would otherwise would have had a smaller percentage of the share, you may have additional people who will get chiropractic services because they'll see the lower copay, and those would be new patients visiting the chiropractor, which again would increase the cost overall.
Utilization.
When the original bill was passed, the theory was if people had better access, used chiropractic care more often, overall costs would be lower, but everybody assumed lower cost sharing means you're going to use those services more. That's generally how it works with insurance.
The other issue that I see that we have talked about for years is now you're setting a precedent. So tomorrow we're going to have someone come in who is, say, a podiatrist who says, I don't want to be a specialist anymore. I should have the same copay as a primary care physician, or your orthopedic guy, or, I mean, are we setting a precedence and opening a door that any specialist type of practice
Yeah,
can come in and say, I don't want to have to pay the same
The
copay?
nature of the profession is, I think the only other one would be a physical therapist. Because really what this problem comes down to is that this is ongoing care. You know, you're getting 12 visits a year. So, you know, you're not going to a podiatrist 12 times a year. The only other person I know you would use regular visits would be a physical therapist. Am I guessing correctly?
Correct.
So that would be the consequences, that physical therapists would come in and want the same thing.
Can I interject something?
Yeah.
So you have to understand that chiropractic care is not only has a lot of health benefits, but it has, and I could have brought a bunch of studies regarding reduction of opioid use. We are in a pandemic with opioid abuse right now. I mean, I've got a bill upstairs, downstairs that I'm trying to get passed. But the issue is the reduction of costs of medicine offsets what we're doing. And we're doing it naturally, and we're getting people well. And it's not just about the manipulation, it's about a total lifestyle change. And I think the health benefits just outweigh the negatives.
Okay.
So, thank you.
Yes, Representative Bartlett.
Thank you, Mr. Chair. I think we really appreciate what you're offering for services, but I have to go back to what the empirical evidence showed us. And when Michael Heaton came from the insurance department, they did have a cost-sharing parity study from 2014 that sunsetted in 2017. And what they said, they found that the lower copays did correspond with higher use of chiropractic care. It did not offset the costs. It did not reduce the use of opiates statistically. It says that, let's see, it did increase the total spending overall without significant decrease in opiate use. And he did have a link to the reports that I don't know, did we receive the link? I can't remember. But I think we have to, I mean, anecdotal evidence is great, and we understand that, but I think we still have to go back to what the real costs will be for insurance premiums. And if we reduce the copays, there is likely to be an increase in premium.
So, Representative, could I ask a question?
Yes, absolutely.
The study was done by whom? I didn't catch.
This
the
came
name.
from Michael Heaton at the insurance department. Tyler, can you help?
Yeah, so Michelle was filling in for me and talked about the two studies we did. The prior legislation had us do a study pretty much right after the bill passed, looking at data, looking at people who had lower cost sharing for chiropractic services versus those who had higher, and then sort of looking at patterns among the population. So this is before the legislation had a chance to have an impact. Then a couple of years later, we looked at the impact of the legislation again to see whether or not there'd been a change over time. And in both cases, you could see increased use of the chiropractic services. The costs overall were higher, but in both of those studies, there did appear to be a reduced use of opioids. In one of the studies, at least, it was not considered statistically significant, but that basically means that you're 95% confident it's not due to sort of random variation. So I think that the representation that it does result in, and it can cause that lower use is probably likely, although in any of these studies, coming up with sort of the causal association is always a little bit of a question.
And she did send us the link on February the 3rd. I do have it in my email, along with 700 and some odd other emails that I haven't opened.
I can send you the links to the reports.
Oh, yeah,
after.
I've got it here. It is from the insurance department.
Okay, Representative Terry.
So I do appreciate the aspect here that that goes to the ramifications related to cost and perhaps ultimately availability of coverage. We already identified that. So I do appreciate that. By the same token, what I understand here is that the same chiropractors want to be treated in the same way under this bill as with respect to the services provided by a primary care physician or an osteopath. So I'm sure everybody here knows the difference between an MD and a DO. So when I sustained an injury and went to an MD, the MD recommended that I go to a DO. The DO did stuff that the DO was trained to do that the MD was not trained to do. Then the DO recommended that I might also see a chiropractor, and the services provided by the chiropractor were very similar to those that were provided by the DO. Now, we already provide a primary care, apparently, copay and an osteopath copay that is, what should we call, minimal? For the sake of this argument, I think we all know what this means. $15 or whatever, okay, entry level, copay, whatever. So if in fact the services that are provided by the chiropractor are similar to those that are provided by a DO, one might ask, why is a carve-out given to the DO to be treated in the same way as a PCP, even though the PCP is not qualified to provide these kinds of services, but not to the chiropractor, and understanding that there's been a historic tension in the medical field between those who have medical degrees, MD or DO, and those who have pursued careers in chiropractic. I don't know how much, Mr. Chairman, I don't know how far down we wanted to get into the weeds on this, but I think that what we need to hear from the advocate of the bill here is that we need to receive a rationale for why providers, chiropractors, need to be treated in the same way as DOs, perhaps even more so than MDs, and as an additional consideration to the ramifications financially that have already been pointed out and discussed and we all acknowledge.
Yeah, to me, it's the 12 visits. It's the monthly visit.
Respond?
Yeah.
Okay. I've been in business 45 years. I'm sorry.
Yeah, nobody sees me. They just hear me. It's like I'm on the radio.
Anyway, I've been practiced 45 years. And my initial practice, I started referring and getting referrals from orthopedic surgeons. It has grown and grown in our profession. Back in the old days, yeah, we were witch doctors, if you want to call it that. That's no longer true. I can't give you the exact amount of schooling that we have compared to a PCP, but it's pretty significant what we do. So what you had said, I get a lot of referrals from medical doctors right now. They don't, I have yet to have somebody refer to a DO and have a DO refer to me. I'm a direct line to the medical doctors. So I hope that answers
just
kind
follow
of.
Right, but isn't the real reason why they're calling you a specialist is because of the amount of visits that you could have on an annual basis?
Representative, Mr. Chair, I have no clue why they call us a specialist.
Okay. Just
okay.
Mr. Chair, just to follow, to clarify here about what I meant when I was talking about, I went from an MD to a DO to a chiropractor, that was incidental. That was my particular situation.
Okay.
We understand that chiropractors are viewed more favorably by those in the medical profession, whether MDs or DOs, than they were years ago. I think that's generally well known and understood. The service, we're looking at the particular service that is provided by a chiropractor that could also be provided by a DO to a certain extent. Not exactly the same because they don't do manipulations, right? But we're in the same ballpark, if not in the same seating section. So what I'm asking is that that you make the case that with respect to these particular injuries or issues, that you ought to be treated in the same way with respect to the copayment as DOs and MDs. That it be a level playing field, and that's what we need to
That's
hear.
what he's asking
Correct,
for.
because, I'm sorry.
Whether it's 12 visits or 120.
Right. I mean, I look at an orthopedic surgeon as a specialist. Okay? I don't look at a DO as a specialist. I don't look at a medical doctor
Well,
as a
that's why I
specialist.
believe that,
So-
that primary care physician and osteopath are effectively lumped or named together.
Well, it also could be a nurse practitioner is the third.
Well, yes, because
They're
this
all-
is.
they're all three
Yes,
the
because
same.
this is 2022,
Right,
you could
so-
put nurse practitioner in there.
Representative Greason.
Thank you, Mr. Chairman. Thank you for answering our questions. If I recall correctly, you stated when we first heard the bill that you are actually a first phone call that a person can make, that you don't have to be referred to a
Correct,
chiropractor.
correct.
So you are in effect already a primary care provider, that you can refer someone to someone else if it's something that you are not capable of providing, but otherwise I can call you directly, book an appointment, so you are already a primary care.
Correct.
Okay, so let me articulate how I see this bill at this moment, and we can see where we want to go here. Historically, us Republicans have said that we are opposed to health insurance mandates. This bill is technically a mandate because we are mandating what the compensation, the premium, compensation for the physician. So, just want you to know that you're crossing that line that people would say, that you're not supposed to be doing that. Okay. What's important here is that the roll of the dice that we're doing here is, if we were to pass this, we are theoretically now making it more affordable for a person to go to do the chiropractic visits. Therefore, that increases utilization. There'll be more people using it. Someone says, well, if it's $10 versus $50, I'll use something more. So the risk is excess utilization, but we're arguing is that's a good thing because we much rather them do this than go to that surgeon who want to cut you open and cost hundreds of thousands of dollars to fix your back. And in that balance, the interesting twist to this is that now we're running the insurance company is going to then decide whether they want to continue to offer this benefit. So they're going to balance that off by how important it is to people that they get chiropractic coverage versus how much increases that utilization, the premium that's being used, and they're saying, oh boy, this is really going to have an impact on premium, so we're better off just dropping it and let the person just pay to the chiropractor.
Let me
out of
further
pocket.
muddy the waters, Mr. Chairman, by observing that what is being proposed here in this legislation is, in fact, I believe, already taking place within the insurance industry with respect to this particular profession. And I cite this as under my plan, I pay $15 copay for a primary care physician. I pay $45 for a specialist, and I
Right.
pay $20 for a chiropractor. So it
So they
appears
already
as though
separate. They already have a separation on that.
So there's already a separation that's being recognized by Anthem. I can't speak to other incumbents, but something is going on even without us getting involved here. And I'm not saying we shouldn't. I'm just saying there's stuff going on that should not leave us with the misimpression that all insurance companies are charging a specialist copay for chiropractic
Right.
services. Thank you.
Are you Medicare?
Am I what?
Medicare. You're right.
Medicare Advantage plan. with
Yeah,
Anthem.
I'm Medicare Advantage, and my
Yes.
plan says my PCP visit is 0.
You
My
must be in a-
specialist is 30.
Yeah.
Yeah, because I'm Advantage.
Right.
Specialist is 30.
You must have a different plan than I do.
Okay.
I'll have to look into that.
Yeah, right. This
So-
is the stride plan.
So we have Harvard Pilgrim, And whether I go to my PCP
Yeah.
or if I go to my chiropractor, it's the same copay. And I have unlimited visits. And let me tell you, I go to my chiropractor before I go to my PCP.
Okay, so you're making the argument that the law is fine as it is then?
The insurance, no, but more insurance companies should be doing this because I think it's a benefit to the people.
They're doing it voluntarily without having to be told that they have to do it.
Right,
But if we can, yeah.
right. That's Representative Greason.
Voluntary.
We love voluntary.
You love voluntary.
Love voluntary. So is a chiropractor considered a specialist by statute or by the insurance companies?
Insurance company.
Okay, so one insurance company can say you're a specialist, one can say you're not,
Or one could carve it out and treat you something differently.
or yeah, you're your own thing. That's cool. You do you, right?
Okay.
Okay.
What do you think, John?
Would you believe? I am a chiropractic patient. I believe the representative knows who I go to down in Derry Chiropractic. I started going there many, many years ago before Medicare, before I was on Medicare. And now that I am on Medicare, it's been great. I have spinal stenosis, and it helps me immeasurably. Going to see him once a month and getting checked out and realigned and stretched and pulled and pushed, and it works. Because if it didn't, I certainly wouldn't be here. Would you believe?
Yes, I would.
All right, Representative Burrows?
Yeah, I mean, this has been alluded to, but when you were talking about the insurance companies weighing the cost benefits, you know, I think we need to go back to when chiropractors were considered boogeymen, and I think they were, maybe you'd agree that they were being sent to surgeons, and the astronomical costs that poses to insurance companies. Is that true that they would normally have gone to a surgeon rather than to this?
Yes.
Yeah, so that's important. Thank you.
Okay, anybody else want to comment? Yeah, Representative Hammond.
Yeah, I too have been to chiropractors over the years, and I appreciate your profession. And I believe it is true that going to a chiropractor in some cases can reduce or eliminate the need to go to a surgeon, right? And in the insurance companies, their desire to reduce costs for medical care and provide lower premiums, they would factor that in, I believe, in their business model. They would look at those, you know, maybe even do some in-depth studying that we're not capable of doing here and factor that in. So, you know, my thought is trust the insurance companies, you know, to some degree into deciding how to incentivize people to go either to a chiropractor or to a surgeon, because we know surgery is very expensive, right? So it's necessary sometimes, but it can be a lot more expensive than 12 visits to a chiropractor. So,
Okay.
Would you believe?
I don't think we're ready to do anything yet today on this one, so we'll bring this up again.
Thanks for your time.
Yeah.
Appreciate it.
And anything you take back from what you heard discussion, feel free to email us. And
I'm going to go to the speaker's office right now.
it's all you're right through the coals over here.
Good luck with that.
Okay. All right, what's next? Pandas. Okay, so the situation with this panda is that in the wisdom of the legislature, when we passed this study to monitor the diagnostic code, we sunsetted it after 5 years. And so what this bill is to remove the sunset so that we would keep studying it or keep monitoring it. Representative Fargo?
I think, and I worked with Becky on this a little bit, the sunset clause was, in the end of 2024, we would stop providing coverage for it, not stop at the
No,
study.
there is no, it's just the study, right? You mean, Tyler, am I doing this correctly?
No, the requirement to cover treatment, including the IVIG, is what would sunset. That being said, if sort of the medical disagreement in the community about what is considered medically necessary shifts toward this is clearly a condition, there's clearly medically necessary treatment, then we would consider it discriminatory for an insurance company not to cover it. I think the sunset date was considered a compromise because there's a lot of uncertainty about how much it would cost to increase coverage in situations that could be concerned about medical necessity, treatment patterns, everything else. Because that led to the conversations about how the insurance department would collect data to look at the costs and the number of patients associated with it, which proved to be problematic using the claims data and the diagnosis code.
But I think, wasn't it true that because they weren't using a specific code, we couldn't get the data that we wanted? We couldn't isolate what the autoimmune deficiency was costing us. But we also didn't see an increase in any other code that would indicate that it was so expensive that premiums were going to skyrocket, which is why they were afraid to approve this in the first place. So my concern is that a lot of people have benefited from having this coverage, and if we take it away from them, there are a lot of people who are going to be hurt by that, because this is a very real problem, and thankfully we have been covering under insurance for the last couple years. If we take that away, a lot of people are going to be hurt by it, and I can't see that it's hurt the state or impacted premiums or anything like that. So I think we have to be really clear here. If we pass
you're
this repeal,
seeing it is a mandate that we said they had to cover it. And so your fear is if we let the thing sunset, then that mandate's gone and there'll be somebody who would not get coverage. That's not what I heard from you. You're saying we don't even have a diagnostic code for this, so we don't even know if anybody's been diagnosed with it.
We have a non-specific diagnosis code. When we looked at the claims data, there were a lot of adults that were coded with that diagnosis code. The overall number seemed to be relatively stable, but sorting out which patients are actually true pandas is not something we would be able to do using the claims data.
Right. So the question is, how do you know that they wouldn't get coverage?
Oh, I don't, but if we repeal this, then, I
Well,
mean, why would we repeal? We said that we were gonna, they weren't providing coverage. We told them, we created this mandate that I remember the discussions.
Yeah.
So that they would have coverage. And if we repeal it, why would we want to repeal this? Because
Well, my memory was there was nobody who didn't get coverage. The problem was that there was no diagnosis. And so that's why passing the mandate seems so questionable to me, because we didn't even know whether anybody's actually being diagnosed.
No, I think the concern was that there was a particular type of therapy for this that
Right, there was a particular therapy. That's it. Harvard
the
and
blood
Harvard was adamantly opposed to that therapy.
was the blood thing, and there were people who said that was not a good course of action, and there were
Right.
doctors who testified that yes, it was, and it had provided relief for people, and that was the big question that we had before we passed it. But we did.
No, I understand.
So,
I
and
think
then
you
my
guys were in the
concern is
majority
if
at the
we-
time, and I was in the minority.
If we repeal this, now can the insurance companies not reimburse people for their treatment for this disease? Because it is real.
So if the mandate did sunset, an insurance company could potentially say, okay, the treatment is not medically necessary. The member would have the ability to go through an appeals process, which could go to an external set
Right.
of clinicians.
I know that one. I wrote that law.
Right, and those clinicians could also agree with the insurer that, yes, there's a lack of clarity, and it's not obvious that this is medically necessary treatment, in which case the insurance company would be on pretty solid ground. They could also say, yes, absolutely, there's been enough development with this disease, identifying it, clarifying that IVIG treatment is appropriate, in which case the insurance company would have to cover it.
But do we want to take that risk, and why would we?
Okay, Representative Bartlett?
Thank you, Mr. Chair. I'm just wondering if we could call Paula Rogers up. She was very involved in this, in these discussions about,
Okay, come on up,
about
Paula.
this,
Come on
this
up.
expensive treatment and how Anthem would look at it
Right, so
if this were
So what
Sounds like it-
happened to this mysterious treatment that Harvard didn't like?
So I think if you look at the biologically based chapter,
You pull the mic a little bit closer. Yeah.
If you look at the chapter, I think it reads something along the line of pandas is tagged on after autism, perhaps. So there's a number of mental conditions, behavioral conditions that are formally recognized. And then there's the little tag of immunoglobulin therapy. Is that correct, Tyler, you're looking at? So I think
Yes.
what you're trying to get at is we might want to get rid of immunoglobulin therapy, but PANDAS needs to be covered. And PANDAS is covered. So the problem is, I suspect there are a lot of people, I think I referenced the fact that the American Academy of Pediatrics has recognized PANDAS. Where the dispute comes is how to treat it. And so, there are a number of indicators that a child may have a PANDAS or a PANDAS-like condition. And the typical treatment would be antibiotics, a steroid, maybe some behavioral health assistance, maybe some family counseling to deal with the behavioral aspects of the disease. The real question last time around was this immunoglobulin therapy. So I can understand why you feel, well, if you rub out the entire language, PANDAS is somehow evaporated. So maybe there's a middle ground. And Anthem's not taking a position on this. I can assure you we've had no complaints about our inadequacy about treating or responding to physician interest in treatments around PANDAS.
To follow up, could you also be able to confirm that there's not been a spike in claims costs when this expensive treatment is covered?
It's not a common condition. So the expenses would be there over the course of the child's experience with this condition. And maybe some therapies, you getting up toward the immunoglobulin, IVIG, and apheresis were the expensive treatments. I don't think we're providing those specifically or we're providing immunoglobulin. And Tyler's looked and he will see the use of that. But the problem is you can't trace it back to a diagnosis where you can say, this is PANDAS. It could be any number of things. So that's the complexity of it. So you could look at that language and say, maybe immunoglobulin is not really necessary, but the PANDAS seems to be, in some quarters, something that they would like reflected in the statute.
If I could
Yes,
speak
good,
also.
sure.
Take a seat. Yeah, okay, you sit there. All right, that's fine.
So I'll try to give perhaps a family's perspective on this. So it is really two different issues, and PANDAS is something, and I think if you ask most families, their number one stressor is actually getting proper coverage. It is a battle with the insurance company, particularly once the condition reaches the level of needing IVIG. So some fairly new data that I picked up from a consortium of people out of California of caregivers around PANDAS. Only about 10% of the most chronic cases require IVIG. And actually the treatment prior to reaching that level is antibiotics or things that are quite affordable and usually covered within policies. The problem is as soon as your child or even adults now reach that level, IVIG, the costs escalate significantly to the point that I can say for our daughter, when she died just prior to starting those treatments, but we were looking at a $32,000 out-of-pocket expense. And all the research that has happened since has really progressed towards IVIG being a very effective treatment for a chronic case of autoimmune. And it's not just PANDAS, there's other autoimmune conditions that are currently using IVIG effectively as well. So really what we're looking at is two things. One is that we're sort of at that awkward period, and I would say a parallel sort of long-term COVID. We all kind of feel it's there, and that it's something there, but how are we going to put a number to that or be able to quantify that when we still don't have a great diagnostic tool for it? So it's still somewhat of a clinical diagnosis of whether you need IVIG or not. And I can tell you that most physicians are quite reluctant to recommend it unless they feel it's absolutely critical, because actually most of the patients they see, not all of them would be covered under the New Hampshire statute because they're being covered by out-of-state or self-insured plans, and it's not unusual to hear them going through 3 levels of appeals and then be declined, and actually the physicians that are having to do this are spending an inordinate amount of time just fighting to get coverage and to get reimbursement, and even if they're successful, usually it's through a very long succession of appeal processes. So the 2 components are important, and really what I think we're asking is that we're sort of at that stage where there's a fair amount of research coming down the pike. Octa Pharma is in a stage 3 clinical trial today, but the results probably won't be available for, to the public for 2 to 3 years minimum. So it's really giving a little bit more time for the research to present itself. We now have a diagnostic, the ICD code 89.89, which is sort of a non-specific but does indicate PANDAS as a diagnosis. In ICD 2023, I believe, PANDAS will have its own diagnostic code. So there is progress towards actually being able to make the data easier to find and easier to report against. And really all we're asking is a little bit more time if the repeal of the sunset is not possible, an extension such that some of these trials that are underway would actually generate some data. In the meantime, the impact to that 10% of the families that need it could be, and typically once you reach that level, a child is unable to go to school. If they are going to school, there's a lot of other factors. They can't get daycare. The condition is such that the IVIG is basically a life changer for the kid and also for the family, frankly, that has to bear that burden. So I think we're really asking for is just a little bit more time. In the meantime, families in New Hampshire are benefiting from it, but there's also many families in New Hampshire that aren't covered by the bill because they have out-of-state insurance that are, and what I would suggest is that if you wanted to study this more, since this bill was passed, Dartmouth has opened up a PANDAS clinic officially, and I've asked them to start collecting data on what they're doing, which is, better than nothing. But I think that could be a source for us also to have an ongoing discussion about this
It
topic.
certainly is a compromise. Yes, Representative Fargo.
So by the passage of the original bill,
Mm-hmm.
it has helped families in New Hampshire and continues to do that.
Right, so exactly. So those families that live in New Hampshire and are covered by a plan that is registered in the state to do business in the state have benefit from the plan. And Anthem, I think, has said they're neutral, which would suggest that it's tolerable to them. I think the other insurance companies have also not been very vocal about saying that this is a detrimental bill to their ability to support it.
So I guess my position is, why would we want to sunset this if it's working and it's not hurting anyone or it's not impacting premiums, it's not.
Well, how do you know it's not impacting premiums?
I just asked Tyler if he saw any effect from it that would affect premiums in any way, and he said he can't even identify where it is because.
Right. So how do you know if we can't identify it? How do you predict premium? How do you predict utilization? Just simply on something that's so intangible as this. Yes, Representative Bartlett.
Well, insurance companies do keep track of large claims. The underwriters are flagged when they see something coming in, and they will use that in their rate making process, so that if the insurance department is not made aware that there are some big spikes regarding a treatment like this, I would think that would be fairly good evidence that it's not directly affecting premium.
Okay. Representative Hammond, did you have something?
Yeah, just looking, the repeal doesn't happen until July 1st, 2024, so there's 2 more there's a whole nother legislative term. There's 2 years to do something,
Oh.
even if we don't do anything today, right? So, but you said maybe more time would give us some more data. But even if we do nothing, there's importance, but not necessarily urgency at this point to do
Right.
anything because the
'Cause
sunset
it's
is
20, oh, yeah, I
is
was
2
thinking,
years
I
out.
thought the sunset was now, yeah.
Yeah.
Okay. So, okay, so, all right, well, we'll talk, let's talk about this some more. We don't have to take this up now. Okay. All right. Okay. All right, relative to pharmacy benefit managers, okay. Yeah. Who would like to make the ITL motion? All right, Representative Ammon.
With apologies to Representative DeLamus if she's in the room.
I think she's afraid to come back to this committee room. And seconded by me. Okay, any discussion on the motion of ITL? All those in favor, raise your hand. 54 by 6, okay. Okay. All right. Well, we got 2 done. Okay. Great. So, just going forward, so starting not next week, but the week after, this committee meets on Wednesdays and Thursdays, and I will be scheduling all the subcommittees, all the 3 subcommittees. I think the next week I'll just try to push through them and not schedule exec session until the following week. So it'll be like the first week in March. Yeah, next week we're all
We're up in Manchester.
we're in Manchester. The 23rd, 24th. Okay, yeah. So there's another. Yeah. Then there'll be another week after that. Yeah. Okay. So that week we'll do subcommittees, and then the following week will be subcommittees and an exec session. Yes. Yes. Anyways, right. So that one's scheduled. Yes. Well, I mean, we'll see. See, we might have some subcommittees pushed into there too, but because you know me, I like to exec sessions shouldn't take too long.
One afternoon.
We got to be finished at that point. Yeah, yeah. No, I'm there for the next. I'm there for the next week. Because I don't leave until the 11th. Yeah. So I feel like we have all the time, and I don't even know whether we're going to get one of these bills that we'll take action on next week. I don't know if we'll get one of those, and if that does, then I have to squeeze it in there somehow. So, all right. Okay. right. We're not your friend.
You guys still in the same place in Oak City?
What's that?
You guys still living in the same place in Oak City?
Is,